him in the hallway or something. Maybe he had to go to the bathroom. You thought you saw him? Oh, okay. Yeah, maybe he just ran to the restroom because Rogers just ran to the restroom. So he'll be right back. He also was looking for coffee, water, and so on. Great. Oh, okay. You never know his. There's Rogers there. Good job.
Oh, that's one of my favorites. Really gets you jacked up. You don't need me.
Get you all jacked up.
Amelia was on the panel.
Oh, was she?
Really great with Justice O'Connor
Okay.
and the
Justice
superintendent.
O'Connor from,
Yeah, the actual Justice O'Connor. She was on the panel with Amelia, and the fellow who is the director of the National Community Legal Aid. I think his last name is Sandelman.
okay.
So it was an excellent panel, and it was all about access to justice. I thought it was a great lead-in to what we're doing here.
What are we doing here?
We're yeah, we're listening.
And asking questions.
Yeah,
Okay.
Yeah. Oh, this is great.
The Chief Justice was there?
She was. It was incredible. Access to Justice. It was a CA put on by ACLU. And you know, last night we were doing a big dinner. Just trying to find out whose district it is. Reducing, you know, not saying that. It could be Rep. Ford. She's on maternity leave. But there's a lady here from Representative.
What's the zip code here?
44106. I don't have any service, so I would be doing this myself, but I don't have any service. I hate to shout out to the audience. Whose district is it?
Well, they may not know because they may not be residents here. Free? Okay.
Thank you again. We're going to be getting started fairly soon, but if you haven't already signed in, we have a sign-in sheet just to your right here at the very back, and we would appreciate you all signing in. Thank you again.
So,
Well, I'm at a meeting. I'm going to be ticketed and towed if I don't see my name here soon.
Yeah, I'm in a 2-hour meeting, so later. I've gotten
I
through
know
it
we
again.
had enough orders for an hour and 20 minutes, you know, why aren't we on different?
Todd, gotta have.
Mike asked if he could be over there because it picks up better on the camera.
Oh, okay.
So,
That microphone.
there's a microphone.
No, there's a microphone. 220.
oh, okay. I'm sorry. There you go. That's all right, I don't have anything to say. Well, here's the button here.
We might have to just take a recess. I don't see this.
Okay, who's sitting next to me?
Oh, you can have it. We'll be playing out together.
Oh, this is yours.
Where'd you
Okay.
That's probably Smith, right?
Smith. Oh, so we'll give Kent Smith.
Unless you made some notes on
No, I haven't done anything. Yep, so. Kent's not a member of the committee, though, is he? No. He is? He's not on criminal justice, is he?
Yeah, he's on the
You
subcommittee.
do? How many? Can you spare? Like, you don't have like 5,000? Because we're all in the same
What do you need?
position here with no quarters to feed the meter. I just probably should pull the microphone closer. We're gonna need some quarters.
Sign in when you come in.
You gotta
Thank
feed
you.
the meter. Okay, so go into your pockets
Okay,
and
well-
find out if you have quarters. We're gonna
How do you
need
get on
those
a
to
similar
feed the
criminal
meter.
justice
Oh, so we're
subcommittee?
gonna ticket
You're
and
not
tow
on
the
main committee?
representatives.
Never mind, I don't want to know.
Thank you. What do you have? Oh, you
How
don't
do you get
have
on the subcommittee if you're not on the main committee?
They find somebody with a full. I don't
No,
know.
we're
Oh, right. I mean, I'm fine with it if you are.
not on criminal
Okay,
justice. I don't know.
so kind. Thank you.
I mean, Dave Levin sits.
Right, and I'll find out at the end of the day, 4:30.
I'm not aware of this.
Thank you for coming. We're glad you're here.
Or know where I can get them.
Yeah, they probably live on campus. Not around. These kids.
That's
I
what I'm
parked.
saying.
I parked in the
Like, they
botanical
probably don't
garden.
even use money.
Sign in,
The
sir?
kids in this room probably don't even use money, and so why do we have meters that take money? Access to justice, think about it.
So they can.
Right, I mean, the meter takes money, you know, kids don't even use money. She just gets me, my thing is at 2:20, 2:15, I have to take a break for the people meeting, if we don't find a person.
Hi,
I
welcome.
parked in the Botanical Gardens.
They're not bad.
Who's here?
Active in criminal justice.
Okay.
Make sure you sign in.
He's not good for pictures though, so he'd rather sit down here.
They won't be behind the curtain where they can be
How are you?
represented. I'm well. How about
Good,
yourself?
good, thank you. It's good to
Great
see you.
to see you.
So,
Great to see you, how are you? Great to see you, thank you.
Did you sign in? Did you?
so,
Sign the sheet at the top table.
okay.
We're,
So I
waiting
guess-
for a very important person. Just the name of that. She has the gavel.
So this was made for Ken Smith, but I'm gonna let him use it since he's on the committee as well.
Good.
It's
You
just the
don't know
packet.
why it's,
Orders from you? Yeah.
Oh, did you get a packet?
I had my guy print me out one, but I'll look at it. I'll keep this one.
Did you have, but there were more this morning.
Then that's the one I'll take.
I have no idea, my phone is on silent, so I texted.
This was,
Is this me? You're also-
no, so, the fair housing, something earlier.
Content provider.
Yeah, but the date is 11. Todd Smith, pertains to the fair housing, meet realtors.
Oh, good, give him that, Mike, do you want?
I don't think that document applies to us.
You'll see people running out because they have to go pay their meters. So they'll be, and they'll come
Yeah.
back in.
Do I get my?
We're all gonna need to do that, because, I don't know what the cost of changing meters out is, but what I'm thinking to myself is it's kind of a barrier. The meter I parked at requires money.
I just parked where there wasn't a meter, there was just a fire hydrant there.
There you go, that's a good
So
one.
it just solved all the problems.
Yeah.
I'm thinking a number of things about how.
So somebody will take care of your car for you.
I'll have a little something for you out
Somebody will
there.
take care of their car,
Somebody
so-
will have it taken care of.
So I have a little note for you when you get out there, Todd.
Thank you,
Uh-huh.
okay?
My car won't be there as well.
No, mine won't be either, not at 4:30. So, and again, I don't have service in here, does anyone?
No, I don't
else
have service.
Yeah. So there's,
Is that tornado shelter or anything?
well, being that there's no communication, that's why this is called the moot. Yeah, it's gonna get worse. The humor
Yes,
gets
sir.
worse the longer the meeting goes. You like that? You guys had to, somebody's had to have said that before.
Yeah.
All these people.
We have it 1:30 to 4:30 slotted, but I mean, it's probably gonna go faster.
I'll swap with you right now.
Yes.
I don't think it is. They said the overall sense of wisdom.
We don't have Bailey here, so that's what Representative Gillespie's aide. She's got all the nameplates.
Can either of
and
you
gavel.
find out whose district this is?
My phone wasn't letting me search it. It was giving me trouble.
Please sign in. Please sign in. I signed in for that. Oh, okay.
I didn't, do I need to
Wow.
sign in, Chairman?
No.
Right, so
We're-
we have
we're-
Representative Kent Smith visiting, and we also have Representative Crossman.
Yeah,
who is not
I have
on the-
those.
Oh, good.
I'm gonna have them stand up when I introduce them. You know, we're gonna get started. We don't have our gavel or our name tags. They will be coming. But, can you all hear me okay? Is this good? All right, so, first, I'm gonna have to use my fist here. Okay, I call this meeting of House Criminal Justice Subcommittee on Criminal Sentencing to order. And will the clerk call the roll? And when you do that, the person will stand, the committee member will stand and state who he is and where he's from, or she. Go ahead.
Chairwoman Grindell.
I'm Chairwoman Diane Grindell from the 76th District, and I'm from Geauga County and part of Portage County. Thank you.
Chairwoman Golonsky.
Thank you. Hello, everyone, and thank you so much for coming. Tavia Golansky, State Representative for the 35th District, which is south of here. It includes southeastern portions of Akron and 99% of the city of Barberton. Thank you again.
Representative Rogers.
Good afternoon, I'm John Rogers. I represent Lake County, the 60th House District, and it's a pleasure to be here. The last time I was here was at my son's graduation a few years back, so he's in debt up to his ears.
Ooh, have to pay it.
Representative Plummer.
Hi there, Phil Plummer. I'm in the 40th House District. That's Dayton, Ohio, just north of Dayton, Ohio. It's good to see everybody.
And Representative Smith.
Todd Smith, District 43, which is all of Preble County and the midwestern portion of Montgomery County, where the city or county seat is Dayton, Ohio.
Thank you all. We have a quorum present. We have the full committee, and we will proceed. Representative Golansky, would you talk about the minutes?
Sure. As soon as I have my aide present, Bailey Sandin, we will review the minutes and make a motion for approval. In the meantime, if you'll all please stand and join me, I would like to lead us in the Pledge of Allegiance. Right behind you. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Well, good afternoon, everyone. We are so happy you came, and so many people came from far away, attending this subcommittee for criminal resentencing. And I'd like to recognize State Representative Kent Smith. Please state where you're from.
I am close by. Cuyahoga County has Euclid, South Euclid, Richmond Heights, Beechwood, East Cleveland, and a little bit of Cleveland, but not this address.
Great. And Representative Jeff Crossman?
Hello, I'm State Representative Jeff Crossman from Parma, Ohio, so not far. I represent not only Parma, but parts of Cleveland, Brooklyn Heights, Cuyahoga Heights. Thank you.
Any other state reps here? Okay. And I'd like to introduce legal counsel Tyler Herman. Thank you. Okay, it's Representative Terrence Upchurch's district. And we look forward to talking with him about this. We wish to open up the dialogue right now between the public and the legislature. We're trying to go from whatever time it is now to 4:30. We all know we are doing something wrong with our legal system. We know that the jails are packed. We don't seem to have a deterrent for crime. The costs are skyrocketing. And we want to help people to be rehabilitated when they come out. It's very important to us. And we want to be educated by all of you and try to write less complicated laws. And Representative Golansky would like to say her introduction.
Thank you. And again, we're very grateful for your being here. Let's consider today to be a beginning of a conversation. We take our work here very, very sacredly. We know it's important, but we need to hear from you. We need to understand what you, the people, want us to be doing in the people's house. We work for you, and we are cognizant of that every day. So today's conversation about criminal justice, criminal sentencing reform begins with you, and thank you for being here.
Thank you. Representative Golansky, would you like to bring up the first person for testimony, or do you want to wait a minute while we get our name plates?
The committee will stand at recess for a moment.
You made it.
Thank you, Malika and Bailey, for finding your way here. We're most appreciative. I hope it wasn't too arduous.
Hi, Malika. How are you? I'm here.
It just came to me.
Thank
Thank you. Right, and I'm just rest 35 about, it's, I gave you the instructions in here, although it might not have gotten to you because you don't have service, I don't have service in here. I'm hoping you'll go outside and have service and you'll get my text. Okay. Thank you. All right.
Again, thank you for the delay. Please proceed.
All right. Thank you. I'd like to call forward Bashara Addison to come forward to testify. We have a seat for you. We have your nameplate there. Thank you.
When you testify, please state who you are and tell us a couple sentences about yourself, why you are here.
Absolutely. Want to make sure that, can you hear me? All right. So good afternoon, Chairwoman and Chairwoman and members of the Ohio House Subcommittee on Criminal Justice Reform and Sentencing. Thank you so much for being here in Cleveland, and also thank you so much for allowing me to speak today. So my name is Bashara Addison, and I live in Shaker Heights, Ohio, and I'm currently represented by Representative Janine Boyd and Senator Sandra Williams. But today I'm actually here as a representative from Towards Employment, which is a workforce development agency in Cleveland, Ohio, and we're serving Cuyahoga County. In 2018, of the 600 individuals we placed in jobs, over 400 of those individuals had criminal records. So this is of critical importance to us. I am also here as the co-chair of the Greater Cleveland Reentry Leadership Coalition Policy and Advocacy Committee meeting, subcommittee, which is also why I'll be stepping out a little early. We have our first big group meeting this afternoon, so I'm going to be here and then I'm running there. Just to give you a little bit of context, the director of the County Office of Reentry could not be here today, so I am stepping in her place, but she definitely wanted to send her regrets. And also to give you some context about the Leadership Coalition, it was formed in 2007 as a reentry task force consisting of city and government officials, heads of local government agencies, corrections, service providers, faith-based organizations, behavioral health organizations, employment organizations like Towards Employment and Passages, and it also includes housing specialists. And overall, its mission is really to guarantee the successful reintegration of individuals with records back into the community, reduce recidivism, and increase public safety. They are one of several Office of Reentries across the country, but there aren't that many in the state of Ohio. And the Greater Cleveland Reentry Leadership Coalition is one of several chapters of leadership coalitions that focus on reentry across the state. And the Ohio Department of Rehabilitation and Corrections helps to oversee that network. Just to give you a little context of how we came to be here. So I work for Towards Employment, and as a workforce development agency that works with adults with records, we know firsthand the barriers individuals face when they are coming back to our community and navigating the labor market. And research shows that serving time reduces hourly wages for men by 11%. It reduces the weeks worked by 9 weeks on average and reduces annual earnings by 40%. And research from the Ohio Justice Policy Center found not too long ago that Ohio is losing approximately $2 billion GDP annually because workers with criminal records struggle to navigate the labor market. So this is an intractable problem. However, there are a number of issues that I believe the State House can take on that are currently impeding the success and contribute to these low earnings and lost GDP as a result of having a criminal record. And so there's 4 issues that I'm going to discuss today and also offer some solutions that are already in the State House that could use your support. The first is fines and fees related to driver's license reinstatement. The second, collateral sanctions that impede access to certain jobs and occupational licenses. The treatment of addiction-related crimes within our court system. So that's not necessarily someone that has a drug-related conviction, but addiction is the driver behind the conviction that they have. The impact of drug convictions on employment prospects, which are 2 separate issues, but there's policy opportunities that I think can address those issues. The first issue on how policy often criminalizes poverty, even unintentionally, through fines and fees, and it disproportionately impacts those who have criminal records. We know that about 13% of all of Ohio's driver's licenses in the state are currently under suspension, so that's about 1.1 million Ohioans. And what you'll find anecdotally is that people are just driving with suspended licenses, which that's not a good thing, because if a police officer pulls you over, one, that's putting them in danger, like if that's happening on the highway, but it also creates an opportunity for someone to be back in the criminal justice system. And most individuals have suspensions for two reasons: failure to provide proof of car insurance, and also failure to appear in court to pay court fines. And this is a workforce issue because many of the jobs in Northeast Ohio require transportation beyond public transit. And so many of the jobs that individuals are taking on, particularly when they are first released, are low-wage jobs. And so individuals have to make this choice between, am I going to show up for court, which is what we would want them to do, or am I going to keep going to this hourly wage job that could lay me off, but I need this job because I know that I have back restitution and fees that I have to pay back from when before I was incarcerated. So you have this dilemma that an individual faces, and they often make the choice to just drive without with a suspended license and not pay or show up in court, which means they're incurring additional costs. And so this trap ensues. We can agree or disagree about the motivations of those individuals and what factors are impacting that person in making that decision. But at the end of the day, we want to have an outcomes mindset. And the outcome is that we want people to be driving with a legitimate license, and we want people to be able to get to work. So how do our policies actually help us get to that goal? And so just to speak to there was a pilot driver's amnesty program in the state of Ohio, and right now there is a policy opportunity, House Bill 285, that has passed the House and has now moved over into the Senate, which is a good thing, that we believe will have a dramatic difference on individuals we serve. And I can give you an example. Between January and July of this year, just individuals that Towards Employment serve, so this isn't looking at the greater reentry population in Cleveland, 47 of the individuals we served would have owed a cumulative $67,700 in fines and fees to BMV to reinstate their licenses. And as a result of this amnesty program, they were eligible to save more than $30,000 through the reduction. And if the participants had been eligible for the full waiver, because the way this policy works is that you get a full waiver for your fines and fees if you are a SNAP beneficiary, I think the House bill actually makes some improvements on that, expanding that definition. In the Senate, Senator Sandra Williams has introduced a bill that's slightly different, but the definition of indigency within that Senate bill is actually the definition we should be using for eligibility within this House bill. So just a clarification, that would actually be really helpful. And so we know this has a dramatic difference on individuals we serve. And we actually have 2 people in workshop right now that have benefited from that amnesty program, the reduction. And they were saying how it's actually put them in a position where they can get on a payment plan and actually be able to get back on the road. So I know, like, firsthand in workshop right now, those 2 people who are getting ready to graduate really benefit from this type of policy. So that is the first issue that would definitely help. Another core issue is the vast number of collateral sanctions that individuals face when they're released from prisons. And just to be clear on terminology, these are a range of legal restrictions that diminish the rights and privileges of those convicted of a crime, and they happen outside of the sentencing process. And they often limit someone's ability to access employment, housing, occupational licensing, housing, and things like that. Right now, there is an opportunity to support legislation that speaks to one element of collateral sanctions in the state of Ohio, and it's around occupational licenses. And it's gotten overwhelming support, bipartisan support, but I know Policy Matters Ohio has given testimony in support of this legislation, and so has the Buckeye Institute. And whenever those 2 groups are on the same page, I'd say it's something worthwhile to support. And one of the reasons why we know that this is an important intervention, most of the studies that look at the intersection of education and recidivism focus on post-secondary programs in prison. So there isn't a body of evidence or research that looks at the labor market attachment outcomes as it relates to someone receiving education. But we do know that prison educations do work and that access to education significantly reduces recidivism. One study, actually, a national study, said it actually has the potential to reduce recidivism by 43%. So we looked at our own data at Towards Employment to say, of our participants that have criminal records that completed workshop, how many of them have actually pursued technical training or credentials, and what are their recidivism rates? And so of the 26 individuals that actually pursued technical training with a criminal record last year, none of them have reoffended, and all of them have been able to maintain at least 90-day employment.
Say that number again.
0% have reoffended.
How many?
So that's 26 individuals. So that is a very small sample size. And right now we have a Department of Labor grant and a contract with the Office of Child Support with our county to actually support individuals with criminal records or child support arrears to pursue technical training. So as an overall intervention, the best practices suggest that this is something we should do. When we look at our small sample size, we know that it works. Our recidivism rate for participants within a year is about 11%, which is still pretty low compared to the state average, which is close to, I think it's 29 or 30%. But when we look at those who have pursued education post-release, we know that it has dramatically reduced recidivism, which suggests making sure that people have access to technical training and a credential or an occupational license associated with it. The small sample size suggests that this is a sound intervention. And so this is something that we would want individuals in the State House to deeply consider.
Please forgive me for interrupting you. It's not a practice that I like to do at all.
It's
We have a moment here where we need to welcome in the students who had to take a makeup class in contract, but who are joining us now. And so if you would indulge me for a moment. Please.
Oh, absolutely.
Hello, everyone, and welcome. We are just delighted that you're here. And not to put you on the spot, but we will be passing around a sign-in sheet. We need you to make sure that you sign in. We're just really grateful you're here. We understand the circumstances of you're coming in right now, and we're just thrilled that you did it. So we're in the middle of receiving our first piece of testimony from Bashara Addison, and so I'm going to go ahead now and let her continue. Thank you, Ms. Addison. Please.
And if someone would take the pad and start passing it around. Thank you. And you are all very welcome. I'm Chairman Diane Grindell, Chairwoman, and I'm co-chair with Representative Galansky.
Okay. Oh.
So please continue. It's excellent testimony.
Well, thank you. And I also have copies of my written testimony, which actually has some of the citations. So if you ever want to use some of the information and know where it comes from, it includes citations and a few more data and statistics. So there's two more issues that I think our state is definitely grappling with. And I think the attention has grown around this issue because of the opiate epidemic. But we know that individuals that substance abuse challenges are not new. And so this has only exacerbated an existing problem. And so we want to be clear that when individuals are either overcoming substance abuse or have been recently released because of their drug conviction, they do experience collateral sanctions. And policy matters. Oh, collateral sanctions. It is a legal term. The ABA, the American Bar Association uses the term collateral consequences, and it is a legal term to say someone's who has been convicted of a crime or an offense, that individual might face barriers to reintegration as it relates to employment, housing, occupational licensing. Nationally, sometimes it includes voting rights. And these are things that hinder someone's ability to reintegrate, and it doesn't happen during the sentencing process, but it is often codified, not uniformly across states, but codified in state law. And we know that there's over 1,000 ways in Ohio state law that we can bar someone from employment, or an occupational license, housing, or different opportunities. Some of them directly relate to someone having a drug possession or a drug charge related offense. And we know that of the 1,000 ways in which we bar individuals from jobs and opportunities, 56% only apply to felonies, which gets into two opportunities in the State House right now that could mitigate this particular problem. Not solve for, but mitigate. We did a data dive with Towards Employment Data to better understand how this issue is impacting those we serve. So in 2018, I now hear myself. Okay. About 100 individuals that we served have drug possession as their most serious offense. So we know that those individuals are going to face collateral sanctions as a result of their drug possession charge. So they're going to struggle to get all kinds of jobs that are growing in Northeast Ohio. We also noticed that separately from that 100 that have come to us for drug-related offenses, that's why they're coming to Towards Employment, is because we have targeted reentry programming. We also had 94 of our reentry participants cite substance abuse and addiction as a challenge for them in finding employment. Only 35 of those individuals actually had a drug possession charge. So that's a really interesting nuance, that we have individuals citing in their initial intake assessments with us that substance abuse and addiction is a challenge, but they actually haven't been charged with anything drug-related. We often find we have some programming in the county Bedford jail facility that individuals are incarcerated not for their drug-related issue, but for things like theft. And it's because the theft is related to their addiction, which gets to two bills that are in the State House. The first is House Bill 1, which has, I believe, passed in the House and is now moving over to the Senate. And it expands the use of treatment rather than conviction for people with drug addictions. That means you could pick up a charge, and if the judge, it gives more discretion to the judge to say, if this individual, their conviction is related to their addiction, they could have their case heard in a specialized docket. And we believe that's really important because it can help individuals get the support they need sooner rather than going through the criminal justice system. I think one challenge in that legislation, so I don't envy your roles, is that we know that individuals who battle substance abuse and addiction often don't heal right away. They might relapse several times over before they can get on the right track. And so that is a challenge in being able to craft a policy, but it is something that is important when we think about the individuals who are coming to us who have offenses, but we know that the driving factor behind that offense is the root cause is actually their addiction. The second is we have individuals who have drug-related charges but don't actually have an addiction. They are recreationally using, which we can have a number of practices to be able to help move someone away from that behavior. But at the same time, we can do all of that, they are still going to be faced with a felony charge or have a felony on their record. And so Senate Bill 3, which was a no-text bill for a long time, amendments were accepted into the bill, I think this week or last week from June. And so there isn't like a summary bill. There's just a draft bill that's on the Ohio Supreme Court website, but the ACLU does a really excellent analysis of it. What Senate Bill 3 would do is reclassify those felony 4 and 5 drug possession offenses, so not trafficking, drug possession offenses only, as misdemeanors. But right now, the text bill is not retroactive, meaning that the 100 individuals we serve year over year who have already been convicted and charged and convicted with a felony drug possession offense would not benefit from this legislation as it's currently written. And there are individuals who would have similar offenses out in the community, but living with misdemeanors, which we know misdemeanors expands your eligibility for ceiling, and it also expands your job opportunities. And so in considering Senate Bill 3, making it retroactive is really important if we want to help the individuals who are already in our community, who are coming to organizations like Towards Employment for help to get jobs. So finally, I'd like to conclude, and I know I've taken up quite a bit of your time, and I will pass around my draft testimony. We strongly urge this committee, both the Reentry Leadership Coalition and Towards Employment, to support policy that addresses the impact of fines and fees in our court system, collateral sanctions specifically as it relates to occupational licenses, the treatment of addiction-related crimes, especially drug-related convictions, which have really been on the rise because of the opiate epidemic, but have always existed in our community, to be able to have policy that can address some of those challenges so people can get back on their feet. I want to thank you so much for giving time to listen to me this afternoon and share some of the stories and things that Towards Employment grapples with when we are trying to help people connect to work. And we look forward to working with all of you on legislation that could have the widest impact possible for those who are eager to participate in our labor market. Anytime you have questions or follow up on any of this, I'd be happy to answer them either here or offline at any time. So thank you so much again. I appreciate it.
Thank you. Are there any questions from the committee?
Yes, I have a couple of questions. First of all, I'd like to thank you again for the excellent testimony. You were able to get into some areas that I've been wondering about for a while. And just before I ask you the question, I just wanted to give the group a little background. I served as a juvenile court magistrate for over 14 years in Summit County, and it was really my privilege to do so. I found out, unfortunately, it was about 7 years into that work, I found out how detrimental it could be for someone long-term for me to apply fines and costs to the work that I was doing to a child, all right? So when I found out what those fines and costs could do to someone long-term, that they actually would be hampered by that well into adulthood, I began a practice of suspending fines and costs on each case. It was a rare case that I would charge a child to pay fines and costs after I received that information. When we know better, we can do better, and we should. So my question to you is, and it might sound facetious, but really it's a question, who are the fines and fees helping?
So, in theory, fines and fees are collected by courts. As it relates to driver's license suspensions, it would be collected by the BMV. As it relates to driver's license suspensions, I recognize, because I gave you a data point, that if we had a full amnesty program for individuals with these issues or these costs, that BMV would not collect $67,000. And that's just with our participants. That's not the wider community who's facing this. And my counter argument to that is you're not collecting it anyway. They're not paying it. They're making rational decisions that may not be legal, but they're rational decision makers in, do I choose between going to work and paying off some of this restitution, or do I show up for a court and then end up in this cycle? People are making choices, but it's not because they are trying to escape the system necessarily. They might just feel like, I just got out, I just got a job, and I have to have some income, because we know that like the two biggest things that impede someone's success is employment, not having employment, and stable housing. But you can't pay for the housing if you don't have a job, if you don't have income. And so someone is making a choice that may not fall in line with what we believe should happen, but it doesn't mean that they're not trying to be a rational decision maker. And so who benefits from these fines and fees? The agency issuing them. But if you're not actually collecting them at all, it's not actually helping anyone, but it is trapping someone in the cycle of poverty and criminalizing poverty. That's what it does.
Thank you.
Are there any more questions? Please, Representative.
Thank you, Your Honor. Addison, very good testimony. So you're involved with the Reentry Leadership Coalition?
Yes, I am.
And so oftentimes in our sentencing, somebody who's sentenced is incarcerated. They have to stay there for the entire term. And then when they're released, they really don't have any reentry means, how can I say this? I guess the point being is I was approached by someone who suggested that if you let somebody out into some type of a home, a group home, 6 months before the end of their term, it helps to facilitate them getting back into society and working, and their recidivism rate is lower. And I don't know, is there any truth to that?
There's absolute truth to that. In Cuyahoga County, there is a transitional housing program for those recent released, but the challenge is that, funding is always a struggle and it has limited capacity. There are shelters in the Cleveland area. Luther Metropolitan Ministries is another social service provider, and they are the largest provider of shelter housing. But I would argue that that's not staple housing. And there is a committee, I am not on that committee, of the Greater Cleveland Reentry Leadership Coalition that is specifically focused on housing rights and housing access for individuals with records. So under the leadership of Director Crystal Bryant, she has reorganized the Office of Reentry and the Reentry Leadership Coalition. So there is an entire team that is focused on just that issue. Those are the two biggest factors that impede somebody's success: not having a job and not having stable housing, aside from some of the other barriers of substance abuse and addiction and some family dynamics that probably also contribute. But if you can nail those two things down, it makes it a lot easier for service providers to begin addressing some of these other issues. So there's a lot of truth to that, and I know there's some studies, and Representative Rogers, I can definitely send those over to your office.
Thank you.
Thank you, Representative Rogers, and thank you to the witness for, once again, eloquently answering that question. Just to let the audience know, we are fortunate to have a witness who is coming forward to speak specifically on the issue of housing during reentry. So I just want to encourage you all to be here for that testimony as well. Thank you. Any additional questions from the committee?
Thanks, Chair. Thanks for testifying in front of us. She has great information, and congratulations on your reentry program. My question to you is, as we see in Dayton, Ohio, we have a serious problem with lack of resources for people suffering with mental illness. And a lot of these people are also addicted to drugs. So we got, two problems going on with the same individual. Do you guys have many resources for the mental health population here in Cleveland?
I would argue that we do. There's Recovery Resources, which I think is partnering now with Metro Health. I don't work for Recovery Resources, so I'm not sure what that actual relationship is, but I know they have been a provider in the County Bedford Jail. There's CATS, Oriana House, which is often known as which I believe there's someone from Oriana House here. They are known for their community-based correctional facilities and halfway houses, but in other parts of the state, particularly northern Ohio, they have substance abuse programs and take-in Medicaid-eligible enrollees. There's Murtis Taylor, the Centers for Families and Children, which is now called the Centers. And I'm sure there's other organizations. I'm not a mental health, behavioral health expert, but I do know lots of those resources exist. That doesn't mean that there aren't challenges to access. And individuals who are cycling in and out of different programs and services, not all of them are the same, not all of them are one size fits all. So I would say even though we have a dearth of resources here, they may not necessarily be meeting the needs. So I wouldn't say that just because we have resources that they're always effective, even though I know that they're definitely effective for some people and definitely needed organizations here. And I'm not sure who the providers are in Dayton, but I can definitely check with my network to see who, and I'm part of a network statewide that really does focus on how you go about dealing with healing and trauma for those who are battling addiction. So I would tap into that network to see if there's any providers in Dayton that your office would be interested in connecting with.
Representative Plummer?
One more question, please. As far as housing goes, how many municipal ordinances are hurdles to, like, group homes? You're only allowed to have 3 people per home. Is that a big hurdle for most people, just municipal ordinances?
So I cannot answer that question because I am not a housing expert. So one, if I know you have someone who's giving testimony as it relates to some of the housing barriers who's here, my co-chair for the Policy and Advocacy Subcommittee of the Office of Reentry Leadership Coalition is definitely an expert. She works for legal aid. And so she could speak to that if she were here. She could speak to that way better than I could because she's done a number of trainings and advocacy around removing some of those ordinances. So I can't speak to that off the top of my head. I'm not the right person to answer that question. But I do know people who do. So I'll make a note that it's connecting with some of the recovery providers in Dayton and also connecting with legal aid in Cleveland. And I know they have counterparts across the state that speak to that specific issue. I can make those connections for your office.
I have a follow-up question regarding Representative Plumbers. You said 25 were clean, which is just incredible. But what about all the ones that we work with and we help and we get into homes, we spend all this money and they restart taking drugs? Can you comment on that?
So
Big issue.
I think you're speaking to the issue of just relapse. And we see that more with the individuals we're serving in the county jail because they pick up either minor felonies or misdemeanors. And those are individuals where we know their offense is directly related to their addiction. And we do see relapse issues. So there's been a couple of opiate settlements, and some of that money will be flowing into some of the workforce boards across the state. And I know that we will be getting some money in Cuyahoga County dealing with the opiate settlement. And some of that money we're hoping will go towards a peer support specialist, someone who has battled addiction themselves and recovered and been clean. We're looking to hire, I think we're getting ready to have that job posting, to bring someone on who can follow up with those individuals so that there's peer-to-peer support. And there is research behind saying that that peer-to-peer support does help individuals stay on track.
So you're saying that sort of like AA, that you have somebody that's responsible with you, working together with you?
Yes.
I think that would help that person.
We're pretty confident that that would help the individuals we know who will come to our workshop. We know that that addiction is a challenge for them. We make the right connections to our partners like Recovery Resources and CATS, but that may not be enough. And so how do we recapture them and follow up with them to make sure that they stay engaged and continue getting support? And so we're bringing on someone who has lived experience who can be able to support that.
Thank you so much, Co-Chair Grindell. What I just wanted to remind the speaker, the certainly testifying, and the rest of the room, just a point of protocol is that we're so grateful for any information that you may have following this meeting. And if you would provide that then to the co-chairs directly, we'll make sure that the committee members receive that as well. And just before we bring up our next witness, unless someone else has questions on the committee, I just wanted to give some background to those of you in the group about this committee. This is unusual in Ohio, but we are proud to sit here as co-chairs. It's usual in committee, certainly at the State House, that you talk to one person as the chair, then you'll have a vice chair, then you'll have a ranking member. But specifically, Speaker Householder and Leader Sykes have set this committee up differently. It is a subcommittee of the Criminal Justice Committee, and Judge Grindell and I, former Judge Grindell and I, co-chair the committee. It's unusual, but yay for Ohio. This is good for Ohio. Bipartisanship and working together is the model that Ohio wants to represent to the rest of the U.S., and you should be proud of that. And so it's a bit unusual that we are on an equal footing here and that we do co-chair the committee, but that is the way that this committee works, and we want to just suggest to you that this is a point of pride here in Ohio. And so I would like to bring up, thank you so much for testifying.
Thank you so much for having me.
Absolutely.
Yes.
And so, excuse me, we do have one more question for you.
Yes.
Thank you.
Thank you, Mrs. Addison. Just a question about a bill that came to my office this week from the Volunteers of America. I want to see how far we want to take this concept of a halfway house. They sponsor halfway houses in our area, which are highly effective. Nobody argues with the data there. If you have a step down from going straight from prison back right out into the community that you came from with no job, we understand that high recidivism rates there. Halfway house, it doesn't shorten the length of their sentence, but it gives them an opportunity to maybe get into some counseling that they need, some help that they need, oversight as they slowly go back into community. There is a bill that is in my office, and I would like even the insight from the committee here, that the way the process works, I take it that the prison evaluates the inmates, I don't know what you'd want to call them, the people that are in the prison, to say who are ones who we think are good candidates for a halfway house. They make that judgment. They turn it over to the judge that is in charge of the case. The judge then has the right to accept that recommendation or to reject it. And what we know, the rejection rates are super high because no judge wants to go back out before the voting population and say, yeah, a guy that I said could go to the halfway house went back out, committed another crime. But these are all nonviolent offenders. And this bill is going to say that we're going to bypass the judicial ability to veto, to say that once the prison says that these people are good candidates for a halfway house, we're going to allow them to go there. Your opinion on stepping over the perspective of the judge in that particular situation, what would you think?
So I feel like I have to take my towards employment hat off and just give you my personal opinion. My professional opinion. I
Are the advantages, is what I'm saying, are the advantages, because we know it's obviously saving money, it reduces recidivism, and it's putting someone back into community who's actually contributing again. The rates are just higher, so there's a positive there, but there's also the negative, I think, is, if nothing else, in just the way it appears, and that is to sidestep the judicial part. So just maybe your professional opinion.
I would imagine that judges would be really opposed to that. I think that I believe that there is a role for A, judicial discretion, and B, that judges aren't all made the same. And part of that has to do with our election process for judges. And so you have some really great judges and you have some not so great judges. There's a couple in Cleveland that are awesome. And then there are others where we have an attorney that represents we have legal services. So we have a consumer attorney and a criminal attorney who represents our participants. So it's not general counsel for the organization. And there's a couple judges where they have a great relationship with the bailiff, and they will say, good day or bad day? And they're like, bad day. So we reschedule our participants, which means the system is not set up to serve individuals evenly. Because if you don't have a Mark Gallagher representing you, then you might be seeing that judge on a bad day. And that's not fair.
So, Ms. Edison, before you get much further, you've been backed into an unusual corner, and I really want to applaud the way that you're attempting to answer this question, and it's excellent. But I do need to inform the audience, and certainly Representative Smith, that actually, as one of the authors of that bill, carrying that with Representative Hillier, would it surprise you to know that actually there's a 10-point system of rating the person that goes to the judge well before. It actually goes to the judge. It isn't a bypassing of the judge, actually. The judge, the person has to be evaluated to even be a part of the program, and that actually goes to the judge. Would it surprise you to know that?
It wouldn't surprise me, and I think I think I was backing into a way to answer this question to not get myself in too much trouble. So I would say that more eyes is better than fewer, which means if we're approaching this in a format like where everyone's part of a team, where we all have common goals to protect public safety, to support the individual, and when we think about some of the dynamics, particularly in a community like Cleveland, where we have faced redlining and lead poisoning, the trauma that children face, and when they become adults, nobody cares about them the same way that we care about children, but they were also victims of lots of failed systems, including our K-12 system. But now they're in the criminal justice system. The criminal justice system, and sometimes I think the workforce system, is on the receiving end of other failed systems, which means we're addressing a lot of things that we weren't necessarily set up to address. So more eyes is better. I would say that you probably do want the judge who is on that case, and also a judge that might be in the community receiving that individual to have at least input. But I think that you don't want the decision to solely rest with one person. So if, let's say, there's a judge who has an input saying like, I don't think that this is a good candidate. And then you have another one that says, oh, no, I actually think that we should give this person a chance. And the corrections officers who've been working with this individual for maybe a year or so, who know them probably pretty well, says, no, I think this is a great candidate. We shouldn't have a policy that denies that person an opportunity to be reunited, because being in a halfway house, usually you're staying in a halfway house in your community, which gives you a chance to help reintegrate and build relationships with your family again, make connections, get a job, doing all of those sorts of things. And we have some great partners in Cleveland, Orion House and Salvation Army in particular, who have always been able to partner with us in helping to connect the individuals at their halfway house to our programming, so individuals are set up for success when they're released. You don't want any one person making that decision. So you probably want a team of folks. So I'm backing into your question that should we deny an opportunity for input? Absolutely not, and so that probably shouldn't be in the policy. But if there is an opportunity, if we don't want a judge to be able to carte blanche say that person is not going to be welcome in my community because I was on their case, because the way that our judges are elected doesn't necessarily allow for quality or equity across the system. And so so do you create a policy when you know that that people don't receive equal justice? You have to take that into consideration.
Talk about awkward. I did not know that you were the author. And it wasn't even an accusation about the bill. I'm in agreement with the principle. I would agree. I actually am a pastor, so I believe in. I said I ended up not going into law. I went into grace. So we believe in trying to help people. So I like this lawyer jokes are the best. You'll like them. I do believe in the principle of that. I was just trying to get feedback, and I would love to hear the Chair Golonsky's clarification of that. From what I'm understanding, it isn't reducing the amount of people looking at it. You have a parole board or some semblance of that in the prison who says this is a good candidate. They would be great in the halfway house, but too many times it seems that the judge, without really a lot of introspection, just says no. There's a lot of them that just say no, we're not giving them that chance because of what it appears to be in the public realm. It's that public perception that you're being weak on crime and such. So what we're doing is we're actually doing a disservice to not only that individual, but a disservice to our community, a disservice to the taxpayers of Ohio by having one person being able to trump all the other opinions of those people who have worked with this individual for years in the prison. And that is, I think that's my understanding of the law. So I think it would be a good thing. And I would ask the chair, is that a proper understanding of your bill?
I'm simply grateful for the dialogue. It came earlier than I thought it would, but I need everyone here to understand, and also in the hearing of my voice, that certainly this does not bypass the judges. As someone who formerly served as a member of the judiciary and has the ear of many judges, I can assure you that isn't the goal. We'll find out later from another witness exactly the detriment that's been done to our community by not offering true forgiveness. We do preach that forgiveness in our Christianity. Also, Muslims and also Jews talk a lot about forgiveness, but we don't actually practice it in the criminal justice system. I'm encouraged by this legislation that I'd like to say is bipartisan, that I'm carrying with Representative Hillier, to actually practice that. And we will have that opportunity. We'll do more introspection about that bill later. I'm so grateful for your testimony. Thank you.
Thank you.
Fisher, we're going to have to limit the testimony to a half hour because we're going to be running till 9 o'clock at this rate. So we need to. When you come forward, you can. Not yet. I would be remiss if I didn't thank Michael from Case Western Reserve University for all his help in setting up this meeting here. And yes, Sherelle, will you please come forward and state who you are and why you're here? It's a little out of order, but she came out from the public and she has to leave. She does not have time, and we told her we could give her a couple minutes.
And while she's settling in, I'd like to introduce to you Sherelle Hardy. And what's wonderful, again, about this dialogue, and we do intend to continue these, is we had a Representative Stephanie House, who is not here today, who produces a newsletter. And as a result of her newsletter encouraging people to come here, many of you are here from her district, hello, and so is Ms. Hardy. And so we wanted to give her an opportunity to testify, reminding you all again, it's the people's house. We work for you, and we want to hear from you. And with that, Ms. Hardy.
Good afternoon, everyone. Thank you so much for allowing me this time to testimony, because when I received the newsletter, I didn't know what it was. But I know that when we talk about true forgiveness with the court system and with the reform, I may not be saying everything, the terminology that should be said correctly, but what I am saying is coming from my heart. I am familiar with tourist employment, but I'm here. I don't know if we can pass a bill or how to get a bill. There are people that have committed crimes and have gone to the prison, have served their time, come out, receive jobs, doing well 10, 20 years from the crime that they committed. And if they're with someone that has a concealed permit to carry a weapon, they're not supposed to be with that person. And they could go back to jail for a crime that they committed when they were 20 and they're now 50, just for being with that person. So I'm wondering, how do you get a bill passed where this person has served their time, they're back in the community, tax-paying citizens, have children. Some of their children may be entering college, but they're around people that carry concealed weapons. Is there an opportunity, or how do we present a bill to prevent this person from ever going back to jail if they are a citizen doing what they're supposed to do? But the law says you cannot be around anyone that has a weapon. They may not know you have a weapon.
Thank you so much. And I'm definitely going to open your question out to the committee here, because we have former law enforcement representatives here. But I just wanted to say to you that it sounds like we have at least two concerns in your question. One is the gigantic concern of what are we going to do about the gun violence. So there are people who feel that they have to carry a weapon in order to protect themselves and for other reasons. And certainly the committee can't actually delve into such a huge problem here today, but I appreciate you bringing forward. The other part of it is what we touched on a little bit earlier, which is what are the requirements and rules and regulations, if you will, on someone who has been released and who has certainly fulfilled their debt to society physically or literally as far as serving their sentence. And they may or may not be on community control, but what sorts of regulations don't need to be in place and which regulations need to be. And just saying that, I'm going to go ahead and turn it over then to Representative Plummer, who has a lot of experience in this area. Sir?
Thanks, Chair. Great question, and that is a concern for a lot of folks, I'm sure. I mean, if you are under a court-sanctioned probation or parole, you can't be around somebody with a weapon, obviously. But you're right, if it's 20 years down the road, you're trying to get back on your feet, you're doing the right thing. So it's something we're going to have to research. I personally don't have a problem with it, and, I'll be happy to look into it for you.
Thank you.
So you need to leave your name and number and give it to Representative Plummer.
Okay, thank you. That was quick.
We're so glad you came in.
We are grateful.
Okay, with that being said, okay, so I'm going to leave my name and phone number and my question with you. How soon should I expect to receive a response, or how will a response come about?
And again, I'm really grateful. What we're going to do is offline. I have my aide who's going to meet with you at the back of the room there to talk about what you can expect here. And it's another great question. Thank you so much for testifying. Any additional questions for this witness? Thank you so much.
Thank you.
I will call the next person to testify, and that will be Andrew Geronimo. Please state who you are and who you represent.
Thank you. Good afternoon. Good afternoon. I'm sorry.
Good afternoon.
My name is Andy Geronimo. I work here at Case Western Reserve University School of Law. I'm the director of the Intellectual Property Venture Clinic. We represent startup entrepreneurs with intellectual property and corporate needs. I'm also a litigator, and in the past year, I've supervised students in criminal appeals and represented an incarcerated person in a civil rights lawsuit. I thank the members of the committee, the subcommittee, for being here today and for taking this proceeding out into the public and bringing it to our law school. I'm happy our students and the members of the public can witness this proceeding. I've taught in the First Amendment lab and the First Amendment clinic here, and I'm an advocate for government transparency and the public's right to know. I co-authored the Ohio Open Government Guide for the Reporters Committee for Freedom of the Press, updated this year to provide the public with a common sense guide to public records, open meetings, and access to court records. I've sued for access to public records and judicial records, and I regularly consult with journalists and researchers regarding access to proceedings or documents of proceedings to better inform the public of the workings of government. The other witnesses you'll hear today can more ably address the nuances of our criminal statutes and how they might be modified to better protect the public, assist with barriers to successful reentry, and simplify the law. While I have some experience representing people who have been convicted of crimes and are serving sentences in prison, I wish to speak to you today about the benefits of transparency in pursuing the legislature's goals. Transparency makes our government more credible, more equitable, and more effective. Ohio recognizes this through various rules, statutes, and constitutional provisions governing access to court records, public meetings, and to court proceedings. Transparency is not just a statutorily or constitutionally required, as the case may be, but is a critical structural component of effective governance by the people. In 1822, James Madison said, "A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy or both. Knowledge will forever govern ignorance, and people who mean to be their own governors must arm themselves with the power which knowledge gives." While Madison's comments were directed to the opening of a public university, his point is more widely applicable. If we're a government of the people and by the people, we should have the means of acquiring information about our government. Unfortunately, as Ohioans, we've seen numerous instances of the criminal justice system creating farce and/or tragedy for the folks it encounters, from victims to defendants to criminal defendants themselves and the public at large. The culture of secrecy is well known among the journalists and researchers in our state who hope to review government documents and proceedings to play this critical role. An example, in 2018, the hosts of the Serial podcast, Sarah Koenig and Emmanuel Dotze, spent months trying to get government and court records from government agencies in our community. Koenig told Scene magazine out of Cleveland here that she'd never encountered governments with such a consistent default mode for secrecy. She said, and I'm quoting from a Scene magazine article here, "I really felt for you guys, that is the local reporters. It would make me insane. Whenever I see information in Cleveland now, I realize how hard reporters had to work to get it. The city is not forthcoming, and not to get too highfalutin, but it's a problem for democracy. If the goal is to make sentencing and other criminal processes more fair, which in my view would serve the ends of making the system more effective and protective of the public, victims, and defendants, we must be able to access and study the ways our courts are discharging their duty to try criminal defendants and punish those convicted of crime. This access is not constrained to just criminal trials themselves, although that is an essential part of it. It requires access to standardized data about the defendant, the court, the charge, and the sentence, which, along with the particular facts of an individual case, can help educate the public about the criminal sentencing sort of on a macro level. I'd like to talk a little bit about court records, and I realize this is a little bit out of your bailiwick here, but I'm hoping there's something that you can work in your creative legislative grace to figure something out. But in the context of the criminal justice system, the
Excuse me, we have two judges here on the bench.
Sure, but judges acting as legislators, not, I'll get to it. In the context of the criminal justice system, the United States Supreme Court has said that the presence of the public, quote, historically has been thought to enhance the integrity and quality of what takes place. That's from a case called Richmond Newspapers versus Virginia. The biggest current impediment to effectively studying systemic sentencing issues is one that the legislature cannot address directly, Rules 44 through 47 of the Rules of Superintendents for the Courts of Ohio. The Ohio Constitution gives the Supreme Court of Ohio exclusive jurisdiction over administrative rules, such as the maintenance and provision of judicial records. The rules of superintendent's access provisions are proving somewhat unwieldy for accommodating the data-intensive empirical studies that are examining and shedding light on system-wide patterns. While the legislature may not be able to alter these rules directly, it could allocate funding for better technology in the courts and advocate for using that technology to maintain statistics that might be helpful in ferreting out systemic sentencing problems, whether caused by discrimination, corruption, or uneven application of law. I'll talk a little bit about expungement statutes as well. I support the Ohio legislatures enacting and strengthening legislation that makes it easier for people with convictions to expunge certain records in order to remove barriers to housing, employment, and to give a meaningful second chance. However, I'd urge the House to be mindful of maintaining some data regarding criminal convictions and sentencing, even if it's anonymized of any identifying statistics about the individual defendant, to strike an effective balance between removing barriers for offenders and permitting researchers and data journalists to study patterns in sentencing. This is already permitted by law in Revised Code 2953-53D, but the Ohio legislature could codify it as a requirement rather than as an option, or appropriate funds to facilitate the collection and maintenance of these valuable data sets. While this is, like I said, it was phrased as optional in the statute, it's worth considering whether maintaining certain statistical data, again scrubbed of any identifying characteristics of an individual defendant, should be mandatory when sealing a record. Although I'm an advocate of responsible data collection and analysis that informs responsible government, I'd emphasize that if we're to meet our goals on fair and transparent reform, we should prioritize responsible use of data and beware of products or services that promise to streamline or perfect criminal justice decisions based on algorithms or other computer-based decision-making. Many of the algorithms underlying these technologies are designated by the entities that offer them as proprietary, and in doing so can frustrate the public's right to know how this government decision-making is being made. There is a growing body of literature to suggest that algorithms that set bail or these pretrial risk assessments engaging a particular defendant's risk of recidivism or failure to appear discriminate against people of color and other marginalized groups. So while access to data is important, it's equally important to recognize the limitations of relying on data alone stripped of context. This is a complex problem, and I can't provide an easy solution, but I would urge the committee to be thoughtful about how to address these larger issues and be somewhat skeptical about these types of programs and the promises that these companies can make. Finally, while this proceeding is primarily concerned with criminal sentencing, I'd like to say a word about the Ohio Public Records Act and Revised Code 149.43 and some of the transparency-related courses I've taught here. I've had students compare the federal FOIA with the Ohio Public Records Act. Both of these laws are disclosure statutes that mandate the production or inspection of certain governmental records on demand, along with a list of exceptions and statutory carve-outs, where the legislature or Congress, as the case may have it, have determined that certain policy considerations override the desire to open the government and its documents. Without fail, the first observation that most students make when comparing the two statutes is the breadth of Ohio's statute and the difficulty in finding applicable provisions or exceptions. 14943 contains 39 specific exclusions to the definition of public record, labeled subsection A through subsection M. By way of comparison, the federal FOIA statute has 9 exemptions. What's more, when searching Ohio's online statutes, I've found over 300 references to RC 14943 in other statutes, the large majority of which are exclusions that aren't explicitly referenced in the text of the public record statute. It's somewhat ironic that the statute meant to give us insight into our government is such a tangled morass of provisions scattered throughout the Ohio Revised Code. If the legislature is looking for a statute to simplify, I'd posit that 149.43 is a good place to start. You could also consider creating a statewide committee on open records, or even consider a constitutional amendment embodying the right to open records in the Ohio Constitution. Once again, I'd like to thank the committee for coming into the law school today and for asking me to speak. I'm happy to answer any questions if I'm able. I've got more of a structural view than some of the other witnesses, so I'm not a criminal trial lawyer. I may not have some of the intimate knowledge of it, but I'm happy to do my best here.
Very thankful that you came to speak, and I asked the committee, do you have any questions?
So if I may, thank you, Co-Chair Grindell. Well, it seems that you agree with one of my favorite phrases, sunlight is the best disinfectant.
That's right.
So I'm very grateful for your testimony, and again, I know it might sound like I'm tooting the horn of the Ohio legislature, but what a great thing that Speaker Householder and Leader Sykes have done specifically in regard to transparency. Did you know that for the first time in our history, all of our committees, I'm not talking about today because this is unusual, but all of the committees at the State House, at the, in the Ohio House, and I believe the Senate now, if the gentleman can correct me, the Senate as well, as being led by Speaker Householder's work, they are all open and streaming live to the public. That is huge. When I heard about that, and I happen to know that Representative House was also part of the negotiation that made that possible, that's huge. Speaking of secrets, unfortunately, before I came to the State House, there were a number of things that were done in secret. And again, reminding people that it is the people's house. You should think about that and how important it is. We're living in the middle of history right now. All of our committees are streamed and open live to the public. And if you don't catch them live, you can also follow up on the Ohio channel and see those. And that is a great thing. So although I can't help specifically with what you mentioned, I have taken good notes here, and I look forward to more transparency in government since it is the right thing. Anyone else with additional questions for this witness?
Thank you.
I don't have any additional questions, but I believe everyone here believes in transparency. And this is a big step. I was in the legislature before, and there are a lot of things that happened in committee that you would have loved your constituents to see. Thank you.
Great.
Representative Plummer.
Thanks for your testimony. A couple things. I'm all about transparency as well, but what do we do about the people that abuse transparency? So here we are trying to figure out how to reform the whole system. You can commit a crime tonight. Before you're found guilty, you're in the paper tomorrow. With Google and all the cell phones, that record never goes away. So now you got problems getting a job, getting housing, and all that. So transparency is a double-edged sword. You know, I was a sheriff for 10 years. I got 30 years in the criminal justice system, and it seems like half my department dealt with pulling public records for everybody and their brother because a lot of people abuse the system. I think Ohio probably has one of the most liberal public record policies in the nation, don't we?
I'm not sure I would say that. I think Florida is generally held up as the gold standard. I'm not an expert in comparative public records law other than Ohio's and the federal, but I don't have specific complaints about the statute itself, but I do have specific complaints about the way it's drafted and the way it's written. So I do think that the legislation as it stands now has done a good job of working with transparency advocates and making that clear. Somewhat of what I'm concerned about is how these regulations that bear upon the Public Records Act are littered throughout the Ohio Revised Code, and sometimes you have to know specifically which statute to look at to know whether or not it's been carved out from the Revised Code.
Well, sometimes the reporters don't have compassion for victims. 911 calls an immediate public record, and the police don't even have the report filled out. The media's got the 911 call on TV, with not a whole lot of regard for our victims. So it does need to be worked on, both sides, good and bad. But thanks for bringing this forward to us.
Sure, and in response to that, I would say that more transparency helps something like that. So if there is a victim or something out there, or even a defendant who's later acquitted, that record itself being public could help inform the public, and hopefully they would follow up on something. I'll also highlight sort of a program that Cleveland.com is piloting around here around the right to be forgotten. So if you have a mugshot or identified somewhere and they determine that the newsworthiness of that has passed, they will delete that story from their records. And that's more of an editorial decision than it is a requirement of any law or anything. So that's something that they're at least paying attention to.
Thank you, Representative Plummer, for bringing that good question up. But that is a very serious problem. I know some people, they're just destroyed. So are there any further questions? Thank you.
Thank you.
Thank you. I would like to call on David Miller to come forward to testify.
Mr. Benza, you are so helpful.
I do my best, Your Honor.
Hello.
associate professor of social work at the Jack Joseph and Morton Mandel School of Applied Social Sciences, which is right across the street. I live in South Euclid. For 10 years, I was city councilman there, and for 6 years, council president. I am currently the chair of the faculty senate here at Case Western Reserve University. I am represented by my good friend, Ken Smith and Kenny Yoko. As I was listening to the other speakers, I was doing some quick research and looking up some things. And I was stunned by the fact that Ohio has the 6th largest prison system in the United States, with 31 state prisons. But I digress. I would like to start by thanking state representatives Ms. Diane Grindle and Ms. Trivia Galansky, I'm sorry if I got your name incorrect, for holding this regional hearing of the Ohio House Criminal Justice Subcommittee and the opportunity to offer my perspective on what is needed for criminal justice reform in Ohio. While I'm not an attorney, I worked inside a maximum security prison in South Carolina as a social worker, which allows me to offer a different yet unique perspective of those for whom you want to provide criminal justice reform. My clients included murderers, rapists, pedophiles, armed robbers, drug dealers, addicts, and others who ran afoul of the legal system. One inmate who went by the nickname of 85, I learned a valuable lesson regarding rehabilitation. Webster defines rehabilitate as to restore to a former capacity or restore to a former state. For the overwhelming majority of the men behind the guarded towers and razor wire, the word rehabilitation was a misnomer. 85 correctly perceived that rehabilitation in the state of South Carolina, and in all likelihood, what happens in this state, as well as others around the country, he and others were being restored to their former selves. Someone without discernible or useful skills once outside the prison walls, but in all likelihood, limited employment and educational opportunities, but easy access to weapons. I come here today to offer that criminal justice reform begins before someone enters the criminal justice system. Ohio, along with many other states, are reactive when it comes to criminal justice reform. If you and your colleagues are indeed serious, and I believe you are, about addressing criminal justice reform, I strongly urge you to heed the suggestions and recommendations of my colleagues you hear today, as well as implore your colleagues from all sides of the political spectrum in Columbus to formulate, implement, and monitor proactive solutions regarding criminal justice reform. I want to say that criminal justice reform begins with assuring that each and every child receives an education that will enable her or him to compete in the 21st century marketplace, STEM or STEAM, science, technology, engineering, arts, and math, that will equip them with the skills and training necessary to compete against their contemporaries from around the globe. Access to multidisciplinary treatment modalities for mental and physical needs, safe and nurturing communities, and the political will to say that every citizen of this state deserves an opportunity to develop and contribute her or his God-given talents for the betterment of society. As long as we have children going to bed hungry at night and traumatized by community violence, attending subadequate, failing, inferior, and under-resourced schools, living in communities where it is clear that some elected officials view them as disposable and where it is easier to find a weapon than a book, your efforts for criminal justice reform will ring hollow to some. As the holiday season is upon us, whether we like it or not, I am reminded of Charles Dickens' A Christmas Carol and the Ghost of Christmas Present. If you remember, the two children which fell out of the ghost's robe were called ignorance and want. Criminal justice reform must forthrightly and steadfastly address these two entities, for they contribute to criminality. Inferior education breeds and spreads ignorance, while in your face avarice in the presence of deep and intractable poverty. We have the perfect petri dish to continue the unseemingly unabated crime and violence in some of our communities. We must ask ourselves, do we truly want to stop reacting to the problem, or are we willing to extend the resources needed to actually doing something about it? With employment opportunities moving further and farther away from urban areas where many of the formerly incarcerated live when they return after paying their debt to society, funding for efficient public transportation so that these individuals may find employment in those distant communities continues to be reduced. The same case can be made regarding funding for health services, both mental and physical, that are needed across this state. I often tell my students, if you go down Chester Avenue, you have the new HEC, which is the Health Education Campus. Or if you go down Carnegie, you have Cleveland Clinic. If you live 2 blocks away from one of those streets, you could throw a stone to Cleveland Clinic or the Health Education Campus or University Hospital. But if you don't have health insurance, you might as well be on an island in the South Pacific that's out of the flight pattern. You don't have access to it. When someone walks out of a correctional facility here in the state of Ohio, what abilities and skills does he or she possess that will make them competitive in today's marketplace? When someone walks out of a correctional facility in the state of Ohio, will he or she go back to a community where they will be able to access the health services needed to heal the trauma from their incarceration and allow them to restore the humanity and move towards becoming a contributing part of the social fabric? Or will they fall victim once again to the bountiful neglect present within their environment to soon be found once again caught up in the criminal justice system? I do have a few suggestions. First, all law enforcement officials, from judges, probation and parole officers, through correctional guards, social workers, mental health counselors, and others, must participate in implicit bias training as a part of their continuing education requirements. Rigorous scientific research must be undertaken by a collaborative team of social and behavioral scientists to investigate and identify how racial, ethnic, economic, gender, and geographical variables contribute to the unequal and inequitable sentencing disparities reflected in the correctional populations. Findings from that research should be employed by policymakers to develop solutions which will put this state on the path to real criminal justice reform. The growth of and rising use of private nonprofit prisons must be ended. While the individuals within those walls may have been convicted by a jury of their peers or taken a plea, they are still human beings and not commodities to be used in the economical marketplace in the ever-expanding prison industrial complex. Wraparound educational and treatment services with adequate staffing, beginning within the correctional facilities and continuing once an individual is released from that facility, must be a high priority. I earlier mentioned the convict with the name 85. His real name was Harry Jenkins. I understand that he was eventually killed in prison, but let me tell you a little bit more about Harry. Although basically and functionally illiterate, Harry possessed a mind that was able to calculate down to the penny how much other inmates owed him for loans he made to them. Whenever his cell was tossed, officers never found pieces of paper or other information implicating him in this activity. I often wondered what would have become of Harry if he had received an education in accounting, or math, or engineering, or even received a GED while incarcerated? What innovations and wonders did our society lose because he received at best a poor and segregated education? Are we willing to continue to lose those like Harry and then come to places like Case Western Reserve University, listen to experts, implore our elected officials to be proactive about criminal justice reform, only to have those same officials go back to Columbus and do? Malcolm X once said, "Those who don't learn from history are doomed to repeat it." Are we going to continue repeating the mistakes of criminal justice reform by doing something after individuals are incarcerated? Or will steps be taken to do something before ignorance and want create more bodies for the ever-expanding prison industrial complex? Thank you for your time, and I'll take any questions.
Thank you so much to the witness for testifying. Your words were something to truly consider. I'd like to open up to the committee, subcommittee, for any questions for the witness. Representative Plummer.
Thanks, Chair. David, thanks for your testimony. I agree with you 100%. We got to get more into the prevention mode. You know, we're spending time cleaning people up, getting them back on their feet, but how much can we do keeping them out of the system at the front end? A lot, right? What's the cost to incarcerate somebody per year? $25K.
A little more than that.
How many folks can we educate for that, right?
A lot. You can get a Case Western Reserve education for that. About one semester, right, students?
So thanks for your passion. I got to go pay that meter out front real quick.
Thank you. Representative Rogers?
Yes. And thank you, David, for your testimony today.
Yes.
Chair. So, in Ohio, we have a number of offenses that require mandatory sentencing.
Yes, I understand.
And so, as a result, oftentimes individuals that are incarcerated under a mandatory sentence have no incentive to do anything, knowing that if I participate in a program or I do something that's beneficial to me, I get no points, I have no early release. And that's one of the questions that has been brought to my attention, because we've taken away so much discretion from people saying that this person should be released early, as opposed to somebody who has to be maintained in prison for the duration of their original sentence.
Yes.
What do you think of that?
You know, I'll leave that to the legal experts in the room, but I would say that individual who is now sitting in there with a mandatory sentence, he started somewhere. And very early, if we had addressed the behavior earlier within the school system, within the community, he might not be in the system, therefore needing those points or saying, I don't want to be involved. But let's say that that person is there. If that person does not have the adequate resources, or the facility doesn't have the resources, whether they're social workers, psychiatrists, psychologists, or they're there once every 6 months or so, that is a fault of the state. Because that individual, most of the individuals that I ran across wanted to improve themselves, but the activities and the services that were available to them was so limited. So they made do with what they made do with. If you look at the sociological literature, all of us want to advance. We have the resources, the education, the abilities to do that. But if I want to advance and I don't have the resources, I don't have the things I need, and I'm not cocooned in a community that's safe, I'm still going to find a way to get mine. And that may bring me in front of Representative Grindell as a judge, or bring me in front of you as a judge. But if we start early, as Representative Plummer mentioned, it's prevention. I come from a background in public health also. Prevention is very expensive up front. But if we can exhibit the patience and time, we will see, yes, expensive here, but it goes down over there. And this isn't a quick fix. We have babies being born across the street. Are we preparing facilities for them in 18 years? Or are we going to put the money into the schools and the education that's needed to make sure that they don't end up needing points to get out?
Thank you. Co-Chair Grindell?
I have a question for you,
Yes, ma'am.
Mr. Miller. If you had one thing that we could do for prevention, and yes, prevention is worth $10 later on.
Yeah.
If you chose one thing, because we can't do everything right now, but
Yeah.
I'm trying to clean the deck and start with something that would be the most valuable thing that we could do for prevention. What would you choose?
I would say early childhood education. I would say early maternal and child health. This state, this county, this city has an abysmal rate of infant mortality. And so the stress that the children are born into, that needs to be addressed. There's a phrase I use, chronic stress. You may have heard the phrase toxic stress, to deal with that stress because the effects of stress can contribute to the development of behaviors that are just outrageous. We live in a community here in which lead is running rampant. Those type of things, prevention. We know that lead in the blood system contributes to aberrant behavior. Addressing those things. I know that's more than one, but I apologize.
Thank you. If I may follow up, I just recently met with Mrs. Anwar Sadat, Jordan, and I asked her the same question because she wants to raise her people up, and her comment was, educate, educate, educate.
Educate, yes, absolutely.
Thank you. I have a question, if I might. Turning your attention, Mr. Miller, back to your earlier statement about health care.
Yes, ma'am.
That piqued my interest in particular. I've heard of something, and I'm not sure that it's true, so if you can answer it, I would appreciate it. And this is basically speaking of pretrial problems that people encounter that hold them back. I was informed that as soon as someone is charged with a crime in Ohio, that they are dropped from Medicaid and other social services roles. Is that your understanding?
That's my understanding. That is correct.
And then, so the impact of then needing to, let's say your charge is dropped, needing to re-enroll and go back through that process. I dare say that none of us in this room are having that experience, most likely, but that sounds like a distinct barrier to stability.
Absolutely. You know, I'm sure you're aware that some of the crimes are committed not out of frustration. It's maybe frustration with their economic state. Food. I still believe that some individuals that I worked with were there because they were trying to make headway in an environment in which there was no other way. I'm not saying it's right, but I've heard several people mention religion, and we have to find a way to forgive. But I believe if we start very early working with our children, the prevention, education, education, education.
Thank you again. Any additional questions for this witness? Thank you so much for your testimony.
Thank you very much. All right, thank you.
I would like to call forward Jonathan Whitmer-Rich to come forward to testify, if you would, please.
Thank you very much. My name is Jonathan Whitmer-Rich. I'm the Associate Dean for Academic Enrichment and a professor at the Cleveland Marshall College of Law, Cleveland State University. I'm very delighted that we have a few Cleveland Marshall graduates. Thank you very much for having me. My comments today will focus on two important, although somewhat unrelated issues, so I'll talk about them one at a time. The first topic is in the area of rape law. And my proposal is that Ohio should eliminate the marital rape exemption. Centuries ago, the English common law took the view that a wife was the property of her husband, and one of the legal doctrines that reflected this property-based view of marriage was the marital rape exemption, the ancient rule that a husband could not legally rape his wife, who was deemed to have consented to any and all future sexual conduct when she agreed to the marriage. Obviously, this is no longer the way we understand marriage, and yet, each year when I teach criminal law, my students are stunned to learn that in Ohio, today in 2019, we largely, not entirely, retain the common law marital rape exemption. So current Ohio law recognizes a variety of sexual offenses, including rape, sexual battery, gross sexual imposition, among others. For all of those offenses, there is only one offense, forcible rape, that can be legally committed by a spouse against his or her spouse. All other sexual offenses stipulate that they cannot be committed by a spouse against his or her cohabitating spouse. So for example, under revised code section 2907.02A1, a defendant is guilty of rape if, for example, 1, the offender uses force, threat, or deception to substantially impair the victim's judgment by administering an intoxicant in order to engage in sexual conduct with them. 2, if the other person is under 13 years old. 3, if the other person's ability to resist or consent is substantially impaired because of a mental or physical condition or because of advanced age, and the defendant has reasonable cause to believe that. For these forms of rape, there is an important exemption. A defendant who did any of these things that the law ordinarily defines as rape is not guilty if he is married to and cohabitating with the victim. Thus, a husband who forcibly drugs his wife to have sex with her is not guilty of rape. This marital exemption does not appear anywhere else in the criminal code. There is no marital exemption for assault or felonious assault committed between spouses, but there is an exemption for sexual battery. There's no marital exemption for forcibly administering a controlled substance to your spouse, but there is an exemption for forcibly administering a controlled substance for the purpose of having sexual intercourse. There is, as I noted earlier, one rape definition under Ohio law that is not subject to the marital rape exemption, and that is forcible rape. So under 2907.02A2, a spouse who purposely compels their spouse to submit to sex by force or threat of force can be prosecuted for rape. But this is the only sexual offense under Ohio law that is not subject to the marital rape exemption. Turning to sexual battery, defined in 2907.03, the provision begins by providing, no person shall engage in sexual conduct with another, not the spouse of the offender, when any of the following apply. It then goes on to list a series of impermissible types of sexual conduct. As is evident from the language I read, being married to the other person is an absolute bar to conviction under any of Ohio's sexual battery rules. For individuals who are not married to each other, it is sexual battery to engage in sexual conduct when, for example, the offender knowingly coerces the other person to submit by any means that would prevent resistance by a person of ordinary resolution, or the offender knows that the other person's ability to appraise the nature of or control the other person's own conduct is substantially impaired, or the offender knows the other person submits because the other person is unaware that the act is being committed. None of that is an offense, however, if the two parties are married to each other. The same is true for gross sexual imposition, which covers lesser forms of sexual contact. All definitions of gross sexual imposition exclude a spouse acting against their spouse. Thus, it is ordinarily criminal to do any of the following, but it is not criminal if you are married to the victim. Using physical force, the threat of physical force, to purposely compel the other person to submit to sexual touching, or purposely drugging the victim for the purpose of sexual touching. All of these marital rape exemptions, I submit, are outmoded by decades, if not centuries. In recent decades, Ohio rape law has been modernized in several important ways. For example, Ohio's rape statute provides that a victim need not prove physical resistance to the offender. The statute also significantly limits the defendant's ability to introduce evidence of the victim's past sexual activity. These are both important changes by which the legislature rejected ancient, outmoded common law doctrines that contravened our contemporary values of gender equality and the rights of all persons, male or female, to their own sexual autonomy. The Ohio Supreme Court has likewise recognized that some ancient common law rules are based on outmoded conceptions of women as the marital property of their husbands. In a different context, the Ohio Supreme Court in a 1992 case evaluated a provocation case. The defendant had woken up his fiancée and hectored her repeatedly to confess her infidelity. Eventually she did, and he promptly strangled her to death. The Supreme Court held that this defendant was guilty of murder, not simply manslaughter, and that he was not entitled to a provocation instruction. The defendant tried to invoke the ancient common law rule that even though generally mere words are not sufficient provocation, there is an exception for confessions of infidelity. The Ohio Supreme Court disagreed. In a unanimous opinion, the court explained that that exception invoked by the defendant, quote, has its foundation in the ancient common law concept that the wife is the property of the husband, unquote. The court then concluded, quote, this archaic rule has no place in modern society. The Ohio Supreme Court was in a position to reject that common law exception in the Shane case because it was only a common law rule, not codified in statute. The marital rape exemption, in contrast, is codified in Ohio statutory law, and thus it must be the legislature, not the court, that repeals this rule. The marital rape exemption, including Ohio's specific law, has been the subject of considerable criticism, and many other states have taken action to further limit or eliminate the marital rape exemption, most recently Minnesota, which eliminated it this year. Ohio should join this modern trend. Bills to accomplish this goal have been introduced in recent years in Ohio, but have not been passed into law. The legislative solution can be quite simple. Simply delete from all provisions of the revised code the language that affirmatively creates an exemption for spouses. I have illustrated those simple deletions in an appendix that is attached to my written testimony. For my concluding thoughts about Ohio's marital rape exemption, I can do no better than the Ohio Supreme Court's comment about that related common law exemption, quote, this archaic rule has no place in modern society. I very much hope that in the coming years, when I and my other colleagues here in the building teach Ohio's law of rape and sexual assault to our students, we will finally be able to say, Ohio, like many states, has now abolished the marital rape exemption. And those are my comments on that particular topic. I'm happy to answer questions about that topic before turning to the next topic that I'll briefly address, or I can continue. I leave it up to the chairs to.
Okay, we'd like you to continue with this one with questions. Are you going to bring your students down to come and testify in committee?
I would be happy to do that. That would be delightful.
Great. And just before we go any further, if I could encourage the other subcommittee members to come on forward, because I know you might have questions for this witness, and we don't need to wait on ceremony here. We're just going to have them come forward. I'm so glad, and actually just thank you for your testimony. I need you to understand that when I came to the state legislature, it was hard for me to look into the faces of the young people who had not embarked on marriage yet and say that here in Ohio, this is the status. That right now, today, there is an exception so that a spouse may, using drugs or alcohol, rape and have their way with their spouse. Right now, today. Now, can you give us, if you may, and I'm all ears, can you give us any good arguments for why we shouldn't immediately pass the bill that does carry my name? I'm one of the sponsors in all candor, but can you give us any guidance, and I'm serious here, about why the legislature shouldn't immediately pass and get rid of those exemptions? I wait for you, sir.
So I think the short answer is no, there aren't any good reasons. I will say that I know some people have expressed a concern about protecting the privacy of the marital home from the criminal law, and I understand that concern, and certainly that is something that we need a sphere of privacy, but I will just emphasize what I said earlier, which is that that's certainly not the original justification for this doctrine, and it's not a doctrine that we apply generally in the criminal law. We don't exempt criminal conduct that happens inside a home simply because the assailants are married to one another. It's an exemption that only applies to sexual offenses. And I think that sort of illustrates that it's not about protecting the privacy of a marriage, many things which need to be private and protected from the public, but some things are criminal conduct, and the state has a legitimate interest in stepping in and providing a remedy. And I think that's the right way to balance those interests here.
I'm really grateful, and I'm going to take personal liberties with a follow-up then. Would it surprise you to know, and are you aware that, in fact, this exemption was removed from the law, but was actually placed back in some 9 years ago? Did you know that?
I don't think I knew that, so I'm really interested to hear that. Thank you.
And the author of that statement for me was Senator Antonio, so I encourage you to reach out to the senator to talk more about that, because in my opinion, that's even more horrible. And thank you for the liberties. Any additional questions for this witness? Seeing none, I'd like to thank you and ask you to go to your next subject matter, please.
Thank you very much. So now on a very different topic, I want to turn to the very important issue of eliminating or reducing collateral consequences of criminal convictions. This fits squarely under one of the subjects of today's hearing, which is assisting rehabilitated offenders who are looking for a second chance. So, indeed, I think this fits very much in with what the speaker and many of the committee members were talking about earlier. The traditional model of our criminal justice system from its early days can be described in three broad stages: a process of determining the guilt or innocence of the accused; then second, for those convicted, a punishment that reflects the defendant's guilt and expresses the community's moral condemnation; and third, once that punishment has been completed, the reintegration of that offender into the community. That third stage, as many of you have already recognized here today, is crucially important. Even with today's very stiff sentencing laws, over 95% of prisoners will at some point be released and return back to their community. Over 500,000 inmates are released annually from state and federal prisons around the country. And unfortunately, recidivism rates remain relatively high. Around 50% of released prisoners will be convicted of a new offense within 5 years of release. So reducing recidivism is obviously a critical goal for many reasons. Obviously, it means reducing the number of criminal offenses, reducing the number of new victims of crime. Of course, it saves the government the substantial cost of rearrest, reprosecution, reincarceration. And finally, of course, it represents a win for the offender, an opportunity for someone who does not recidivate to put the past behind them, move forward into a productive life that contributes to their community rather than draining resources from it. There are many obstacles, some of which have been discussed during this hearing, standing in the way of an offender who has served his or her time and is returning to the community, from a lack of financial resources, mental health and drug addiction problems, lack of job training. The halfway house program that was discussed is an excellent example of a way to try to address a lot of that. I want to focus on one particular obstacle, which are known as the collateral consequences of criminal convictions. So after a conviction, a judge imposes what we refer to as the direct consequences of the conviction, and many of you are familiar with this as being judges. May include fines, probation, time in jail, time in prison, among other things. Collateral consequences are ordinarily not imposed by the judge, but are created by statutory rules that impose additional future burdens on a person convicted of certain crimes, restrictions on where they can live, what jobs they can hold, whether they can vote, among other things. These collateral consequences have proliferated dramatically in the past decades, around the country really, and these many limitations are a direct impediment to one of the stated purposes of the hearing, to assist rehabilitated offenders who are looking for a second chance. To show the scope of this problem, I tried to look at one simple example. Let's consider a person convicted of a simple assault at the felony level. Sometimes simple assault in Ohio is a misdemeanor, sometimes it's a felony of the 4th or 5th degree. And note that when a defendant is convicted of regular assault, this indicates that they knowingly caused physical harm to someone else, but the harm was not serious. If it had been serious, it would be a felonious assault. So taking that example, the Ohio Justice and Policy Center has created an online database that enables us to see what type of collateral consequences flow in Ohio from different types of criminal convictions. And so using that database, I determined that a felony level conviction for simple assault carries with it 603 collateral consequences, including the following: cannot serve as an officer of a credit union, cannot serve as an unpaid bingo game operator for a charitable organization, cannot be granted a manufactured home installer's license for 2 years, cannot receive an auctioneer's license for 10 years, disqualified from sitting for the building trades contractor exam, cannot receive a license to be an out-of-state mortgage loan originator for 7 years. Those are all automatic prohibitions. Statutes also contain a long list of discretionary rules under which some certain board or organization is entitled to consider whether this simple assault conviction should bar the offender from certain occupations. So again, discretionary limitations that could be imposed for this simple assault conviction would include prohibitions on holding the following occupations: pesticide application, dental hygienist, emergency medical technician, manufacturing bingo supplies, and real estate broker. I'm going to go briefly off script here. I will say this morning I was down at the Supreme Court at a Ohio Rules Commission meeting, and as I was driving back to this meeting, I was with one of my students, and we were talking about my testimony today, this afternoon, and she said, "Oh, I have a friend who was in school to be a dental hygienist, and she went to this concert with a bunch of her friends, and they searched her backpack, and some of her friends had put stuff in the backpack, and there were drugs in the backpack." So, of course, I'm not here to tell you whether she knew they were in there or not. I don't know. One way or the other, she was convicted. She spent a little bit of time in jail, and she found herself unable to become a dental hygienist that she was in school for. I think that was dramatic to me that the student who I happened to be riding with had a story of this from a friend of hers. And I think it was dramatic precisely because the offense that she was convicted for bore so little relationship to the occupation that she was trying to pursue. And it seemed such a needless and damaging impediment that was put in her life. So the extreme proliferation of collateral consequences places literally hundreds of roadblocks in the way of individuals who have completed their court-imposed sentence, and it makes it significantly more difficult for those individuals to be given a second chance at pursuing a lawful career and successful reintegration into the community. It certainly can be argued that some collateral consequences are appropriate in narrowly drawn circumstances. I would agree, for example, obviously, that an individual who was, say, convicted for sexually assaulting a young child should not be employed as a direct caregiver at a daycare for young children. The problem, however, is that hundreds of individual collateral consequences apply to countless separate offenses under Ohio law, very commonly with little or no serious nexus between the offense and the resulting collateral consequence. I would suggest that collateral consequences should be evaluated from the legislative perspective under the type of test that in court, the courts use in equal protection law known as strict scrutiny. Is the collateral consequence narrowly tailored to serve a compelling government interest? I think that a legislature that applied this kind of strict scrutiny to test collateral consequences would reject most of them as too broad and lacking in sufficient evidence that they truly serve a narrow and compelling government interest. I think that dramatically reducing the hundreds of collateral consequences that exist today under Ohio law is a crucial step toward enabling offenders who have completed their court-imposed sentences to move forward in life instead of becoming a permanent social outcasts, adding to Ohio's recidivism statistics. Collateral consequences should be imposed only in the narrowest circumstances when they serve a compelling government interest. The vast majority of collateral consequences fail this test and should be eliminated. Thank you.
Thank you very much for the testimony. Are there any questions for this witness? Co-Chair Grindal?
I have a question regarding the balance. You said that, this example is a typical example. I'm sure there was no knowledge of the law of something like this. We don't seem to have any deterrence. How do we balance deterrence that we need so people do not commit the crimes versus something sort of peculiarly related to the crime?
Yes, thank you for the question. I think that the striking thing to me about collateral consequences is they are not really, I think, designed even to serve as a deterrent effect. They're sort of designed, when they're designed properly, to say, well, certain people who have demonstrated certain conduct simply should not be eligible for certain types of positions in society, what have you. But really, the deterrence in our criminal system comes from the substance of the criminal law, what's prohibited, from law enforcement, and by far the most effective. I think that the research shows that you want criminal conduct to be detected quickly, and then to be swiftly, a high level of certainty, swiftly punished, but it doesn't have to be punished that severely. So the swiftness and the certainty are the things that really get the deterrent effect out there. People who understand that if they engage in this conduct, they will quickly be caught and face the consequences, that hits home. The length of the consequences are less important, but the certainty and the swiftness with which we can impose them. So I think that's what I would say about deterrence.
If I may continue, the reason I say that is that I know so many law students told me they are not going to do this, they're not going to do that, and because they want to become lawyers. And
Right.
they'll never be able to be lawyers. So
Indeed.
so that is sort of a deterrent, but you bring up other good points.
That is a good point, yes.
Representative Rogers?
Thank you, Chair. And thank you, Professor. Just so, when you're talking about swiftly, we have a legal system where somebody's charged with a crime, and it may be 2 or 3 years before the trial actually occurs. So how do you improve on that? I mean, speedy trial rights, lawyers waive the rights. They sit in jail, get time for served. But in reality, you know, it's broken in a way when you're talking about trying to impose something swiftly.
I think that's a very good point, and I particularly like your emphasis on the fact that lawyers waive speedy trial rights very, very commonly. And I think what's lost in that is that the public has an interest in a speedy trial that is separate from the defendant's. The defendant also has an interest in a speedy trial, but the public has an interest. And I think that it would be interesting to explore legislative solutions that recognize that public interest more strongly. I know that in the federal system, for example, it is more difficult for defense lawyers to simply keep waiving speedy trial because that public interest, I think, is more strongly recognized under the federal rules than, in my understanding at least, it is currently under Ohio law. So that might be one way to try to emphasize the public interest in the speedy trial.
So, second question, I believe we are considering legislation in the committee today that deals with an extension of speedy trial rights, so that, I think in Ohio it's 270 days, and so as you're approaching that 270-day limit, if you're not brought to trial, what they want to do is they want defense counsel to notify everybody 2 weeks in advance, and then after that time frame, the prosecutor has another 2 weeks to be able to bring the case to trial. So, and you know, as a former prosecutor, if I lost the case on speedy trial, I lost my job.
Right.
And so,
that's part of the job, to keep that clock in your head.
Right. And so, but there are situations, I'm told, about 50 to 60 a year in Ohio that, you know, that situation arises where they need additional time. And I sit there and I think in my county, maybe 1,000 felonies, you know, 10% go to trial. How many cases that were charged as felonies are reduced at the muni level? And I just wonder, do we really need to address the law so that we can protect something that I would think that a good attorney would be cognizant of and protect themselves?
I would agree with you, and I think that, so again, to contrast, say, the federal system, there are reasons that you can extend the speedy trial clock in the federal system, but one thing that a defense lawyer cannot do is prospectively waive the speedy trial rights in the federal system, because you can't let the government off the hook from their speedy trial ahead of time. If the government articulates particular reasons why they need more time, you can get extensions. In Ohio, in contrast, my understanding is you'll have those waivers that happen, and so I think moving to a system like that where it's actually a bit tighter and it's less likely to get waived might allow prosecutors to be even more cognizant that this is not something that I need to think of on day 270 and then ask for a 2-week extension, but rather I need to be thinking of really seriously from day one.
Thank you.
Thank you. Any additional questions for the witness? Yes,
Thanks,
Representative
Jeff.
Plummer.
Thanks for your testimony. It's great stuff. I'd like to see people use a little common sense into this equation. We kind of lack that occasionally, but I'm new at this whole game. So I think this body ought to really look at these consequences, collateral consequences. This is one of the biggest hurdles I've seen in the criminal justice system. This and driver's license consequences. I mean, you know, don't pay your child support, they take your license from you. Who'd that make sense to, right? So now you can't go to work to pay your child support. So we got to make this a priority of ours, because it is a huge hurdle out there. Part of the speedy trial aspect, I think the majority of the defendants are represented by public defenders. And we did send more money back to the public defenders to try to expand that capacity to hopefully speed up some of that as well. But what percentage of defendants are handled by public defenders? 90% maybe?
Well, either public defenders or appointed counsel, which are being paid for with public funds, and it is pretty high. It's maybe 90%, yeah.
Yeah, God bless them, but I'm not so sure a whole lot of justice is being worked out with all these plea bargains because of the caseloads.
Thank you. Any additional questions for this witness? Seeing none, thank you so much for testifying.
Thank you very much.
Our next person that's going to testify is Rachel Dursey. And I have to tell you, we're looking at the time, and I promised everybody we'd be out of here by 4:30, and we have 3 people counting yourself.
Good afternoon. I promise mine is very short. So my name is Rachel Dorsey, and I am the Cleveland Director for the Center for Employment Opportunities, which I will refer to as CEO for the rest of the testimony. And I'm really just here today to talk and introduce what CEO is doing in our community and in the state of Ohio. So CEO's mission is to provide immediate, effective, and comprehensive employment services to individuals who have recently returned home from incarceration. We serve individuals coming home from prison in Cleveland, Cincinnati, and Columbus, with a focus on those with the highest likelihood of recidivating. CEO's approach has been rigorously evaluated and shown to reduce recidivism while also returning more than $3 for every $1 of public investment, particularly when our services are focused on individuals with the highest likelihood of returning to prison, especially those who have recently come home. Our program has 2 core components: transitional employment and vocational services that are provided to help participants get and keep full-time jobs. For our transitional jobs, CEO operates 7 crews throughout the state that provide a variety of general labor services and public and private sector entities. All CEO participants access immediate work and immediate pay on CEO's transitional work crews upon returning from incarceration, while simultaneously working with CEO's staff to gain permanent full-time employment. Since launching in 2017, CEO Ohio has hired more than 730 participants as CEO employees in transitional jobs and made more than 380 permanent job placements throughout the state of Ohio. CEO's funding model is unique from other reentry programs in that we are able to leverage funding from multiple public and private sources to support our work. CEO launched in Ohio through a multi-agency partnership called the Road to Work program. The program is housed within the Department of Administration Services and brings together ODOT, ODNR, and ODRC. Through this partnership, ODRC provides referrals to CEO, and ODOT and ODNR receive beautification services along state highways and in state parks. The Road to Work program has also enabled CEO to leverage federal pass-through dollars through a statewide contract with ODJFS, SNAP, and Employment Training Program, which supports CEO's vocational services in all 3 of our Ohio offices. This is a unique arrangement where the cost of our work doesn't entirely fall upon the state. CEO believes Ohio has the opportunity to become a national leader in keeping people out of prison and in the workforce. The need of the state vastly exceeds CEOs and other service providers' capacity, as more than 20,000 Ohioans come home from prison every year. CEO has a 20,000 in just in Ohio. CEO has a multi-year goal of growing to be able to serve half of our target population in major metro areas in order to be able to have a tangible impact on recidivism in Ohio. By expanding on the Road to Work program and continuing to make additional investments in reentry employment services, this growth is attainable. In addition to scaling our services in Ohio, CEO is also working to engage participant voices in our policy work to identify ways that we can help address the systemic challenges that they face after release, increasing their economic opportunities and reducing collateral consequences from incarceration. CEO not only seeks to service participants, but to empower them as well, as their voice is critical in seeking an end to many collateral consequences of incarceration. Collateral consequences can increase recidivism by limiting or by completely barring formerly incarcerated persons access to financial or other resources and personal and family support. In addition, the general public, lawmakers, and courts often lack knowledge of what the totality of the collateral consequences are in their jurisdiction, how long they last, whether they are discretionary or mandatory, or even if they are relevant to public safety. Our participants' voices are critical to identifying and addressing these issues. CEO hopes to engage state leadership in this learning process that brings forth the lived experience and expertise of our participants, and that CEO's organization will be stronger as a result of this effort. We look forward to further collaboration with you in the process, and I thank you for your time.
Thank you so much.
You're welcome.
Ms. Dursey, for your testimony. Do we have any questions for the witness?
I do.
Representative Rogers?
Thank you, Chair. And thank you, Rachel. So you say we focus on those individuals with the highest likelihood of recidivating and taking into consideration collateral consequences. I guess for excluding collateral consequences, what parameters do you measure, or how do you identify someone that you think is going to recidivate as opposed to someone less likely to?
Yeah, so typically they are under the age of 31, so what's considered young adult. They have multiple felonies, and they are very recently released from incarceration. Yep. All right, thank you.
Any additional questions for the witness? Thank you very much.
Okay,
witness.
thank you very much.
Thank you.
Okay, the next witness is Michael Randall, if I'm saying it right. Oriana House.
Well, good afternoon, Chairs Grindell and Galansky, members of the Criminal Justice Subcommittee on Criminal Sentencing. I'm Michael Randall. I'm a vice president with Oriana House. Oriana House is a community corrections and chemical dependency agency that's been around for 35 years. We have programs in Akron, Cleveland, Fairmont, Marietta, Fremont, Marietta, Sandusky, and Tiffin. I'm also a president of the Ohio Community Corrections Association. OCCA represents 39 nonprofit residential reentry centers, also known as halfway houses. We also represent 5 of the 18 community-based correctional facilities throughout the state. I'm testifying today in support of transitional control veto reform. Also, the language that has been proposed in House Bill 403, sponsored by Representatives Hillier and Galansky. Because of the time, I'm going to abbreviate my comments and get right to it. As you know, the Ohio Revised Code 2967-26 allows the Ohio Department of Corrections to establish transitional control. Transitional control essentially allows an inmate to be transferred to a community residential program or a halfway house for up to 180 days prior to the expiration of their sentence. They maintain that inmate status even when they're at the halfway house. In other words, if they don't follow the rules, if they don't follow the programming, they're returned to prison. Also, the Ohio Revised Code and ODRC's administrative regulations specifically disqualify certain offenses from eligibility for transitional control. For example, sex offenders are not eligible. Certain offenses of violence are not eligible. Excessive felony convictions are not eligible. Those individuals serving mandatory sentences are not eligible for participation in transitional control. I actually have with me the actual screening tool that the Department of Correction uses when they determine whether or not a person's eligible for transitional control placement. This screening tool is used even before the Department of Corrections requests approval from the judge for placement on transitional control. The other, I think, really important point to make is we're talking about a subset of the population in the prison. In other words, specifically, those offenders that are serving 2 years or less are the people that we're talking about when considering them for transitional control. The other segments of the prison population, as long as they meet those criteria, the Department of Corrections already has the latitude to place them in transitional control. By them being the 2 year or less population, we're talking primarily felony 5s and felony 4 offenses. So I thought that was an important point to make. Data suggests that by applying this criteria, we're sending the right offenders through transitional control, as evidenced by the lower recidivism rate. Currently, inmates released from Ohio prisons have a recidivism rate of 31%. By placing them in transitional control, those offenders that are placed in transitional control have a recidivism rate of 16%. Obviously, these folks, while they're in these programs, they get drug treatment, they get alcohol treatment, they're given an opportunity to work while they're there, they pay child support, they pay restitution, they do all of those reentry supports that you all very well know are really important for their successful reintegration. The drug treatment programs are certified by the Ohio Department of Mental Health and Alcohol Addiction Services. The operations inside these halfway houses are audited by the American Correctional Association as well as by ODRC's Bureau of Community Sanctions. We enthusiastically support the change that is being recommended in House Bill 403. This bill has bipartisan support. There has been a lot of discussion about it today, and so I will yield the remainder of my time for questions. Thank you.
Thank you so much to the witness. We will open it up for questions, but I think we need to get very specific about this law. If we do nothing, what is the current law on transitional control right now?
If you do nothing, those offenders that have 2 years or less, the Department of Corrections will continue to screen them. They'll send a request to the judge that this person meets the criteria for transitional control placement. Judge, are you willing to approve placing them on transitional control? Right now, judges veto those requests at a 47% rate. That equates to 1,100 people that are in prison that otherwise would have been eligible for transitional control placement. Now that's the size of a prison, essentially. So to answer your question, specifically, the department cannot place them on transitional control. The interesting thing about this is they're coming home anyway. So it's either we send them out early in this kind of environment where they can go into a halfway house, or we keep them in prison for those additional 4 or 5 months, and then we release them directly to the streets.
So specifically, and I will get to all these questions, specifically, if we do enact the law under 403, how will this law change? Please explain that to the committee members.
If we enact the provisions in House Bill 403, it will effectively remove the judge's ability to veto the placement for that subset, that group that I've described earlier. So the Department of Corrections will still screen them. The Ohio Revised Code still specifies who's eligible and who's not eligible for transitional control placement. It takes the request that the department has to make to the judges out of the equation. One other thing, Ohio is the only state where we actually ask a judge. Once a person is adjudicated and sent to prison, it becomes a Department of Corrections function. The Federal Bureau of Prisons they have release programs that are similar. They don't ask the judge. So it's a unique situation, and we've been looking at this issue. This isn't the first year, the second year. There's a long history of looking at transitional control because it is the most effective release option that the Department of Correction has. So.
Again, excuse me for taking liberties, but are you talking about opening up jails and letting people run willy-nilly all over Ohio, or are you not? Can you please explain what will happen with these inmates?
Representative Golansky, these are inmates that are serving time in prison. Once they come to a halfway house, they are required to be under the supervision of the staff at the halfway house. They're drug tested routinely. They have a period where they're not allowed to go out. We structure their access to the community. We track them In some cases, we have electronic monitoring available for certain offenders. And again, if they don't follow the rules of the programs, they're sent back to prison.
Representative Rogers?
Yes. So just to follow up on your question, so I find it interesting when you talk about an average of about 45%. In the county last year, I think it was 8%.
Sure.
But there are a number of counties where the judges just completely veto
Yes.
all requests.
Yes.
And, so I'm inclined to agree with you that the judicial component of the review should probably be alleviated. Do you have any reason why do you think they do that?
Over the years, Representative Rogers, I've talked to judges, and again, we've tried to work through the judicial conference over the years and talk with judges. Judges, they have a variety of reasons, but mostly what you hear is they want to maintain that discretion, and it depends on where you are. And by that I mean this. If you talk to a judge from rural Ohio, where they have a small number of people that they're looking at that fit this category, they're the same people that the judge says, look, Mike, I've been seeing this guy over the years. He hasn't done anything really serious. He's got a serious drug problem. I don't have access to treatment in my community, so if I send him to prison, he'll get drug treatment. Well, we all know how that works, and I can tell you, because I've been a warden in prisons in Ohio. By the time they make it to that reception center, they will have served time in jail going through the adjudication process. They'll spend time at a reception center. By the time they get to their parent institution, half their time is already up because they get credit for jail time served, they get credit for time in the reception center. Then they get to the parent prison, where I'm the warden. I've got drug treatment programs, but I got a 2-year wait to get in those drug treatment programs in my prison. Not because I don't want to provide that service, because I can't, because I got 2,000 people in this prison. So that person, their last 6 months, they're sitting there essentially, can't get into treatment, and they're waiting on an out date. And what we do, when their date comes up, we give them $75 gate money, we drop them off at the Greyhound bus station, and the cycle starts all over again.
So if you put the transitional control into place, you eliminate the judge. What happens with respect to somebody that has a substance abuse issue?
What happens is, if a person is approved for transitional control placement, the provider, one of those 39 nonprofit halfway house providers, go and pick that person up from prison, transport them to a halfway house. They receive assessments that cover everything from education to substance abuse needs to employment needs, those things, and we begin to work with that person. If the person's number one issue is drug treatment, we're going to get them drug treatment, whether it be us providing it through our agencies or referring them to local community drug treatment providers. So that person will receive treatment while they're there. In addition, we try to establish those long-term supports by getting them eligible for Medicaid. So when they're done with their 4 months with us, they have Medicaid eligibility established so they can continue with their substance abuse treatment. Many of our programs offer medication-assisted treatment, which is one of the most promising aspects of substance abuse treatment now. So we work directly with those folks to get them to do a smooth handoff between the prison and the halfway house.
Thank you.
Thank you. You sound very knowledgeable, and I don't know if there's any other questions.
Thank you, Representative Plummer.
Chair, thanks, sir, for your testimony. I'm a big fan of you guys. I think you guys work really well. I think we gave you guys some more money, too, this budget cycle, didn't we, to help you retain qualified employees?
Yes, thank you, Sally.
Well, you guys needed that. So you guys have capacity, so obviously your head count will increase. Do you have capacity if this goes through? Can you handle this?
We recently surveyed the 39 halfway house providers across the state, and there are about 600 beds that could be brought online if needed. If, for example, those 1,100 offenders that I talked about that would have otherwise been eligible for transitional control placement, if 403 passes, moving forward, that population will be eligible for placement in a halfway house. Because the average stay is about 104 days for a halfway house placement, those 600 beds would more than accommodate over a year's period of time. So there is capacity. No new capital investments would be required for this.
Thank you, and we really appreciate your testimony. Like I said, you're very knowledgeable, and
Thank
it
you.
sounds like you've talked with the judges.
Yes, we continue to talk to judges, and quite honestly, not all judges are
Receptive.
yes, but again,
Thank you.
thank you.
Thank you. I'd like to call forward to testify Sonia Mattis.
Good afternoon. Good afternoon, Co-Chair Galansky and Co-Chair Grindel. I am honored to testify in the first Regional Committee meeting of the Ohio House Criminal Sentencing Subcommittee.
We're happy to have you here.
Thank you. My name is Sonia Mattis, and I am a survivor of childhood sexual abuse, domestic violence, and sexual assault. Today, I volunteer in women's prisons, rape crisis center, and domestic violence centers. I am a proud member of the Crime Survivors for Safety and Justice, and in March of 2019, I joined over 200 members of Crime Survivors for Safety and Justice for Ohio first annual Survivors Speak convening to share my story with legislators and offer my support for shifting toward drug treatment and earn redemption as a pathway out of addiction. I also advocate to grow trauma recovery centers in the state of Ohio to ensure that underserved victims of crime get the healing support needed to recover from violence. Every time I enter the women's prison to speak, I am reminded that the only difference between those women and I is that I was able to get some help. They did not get help and ended up behind bars. I can tell you from personal experience that victims of sexual assault often feel a tremendous amount of shame. That cannot be washed away. Too often, victims of crime who are not offered the appropriate support turn to substance use to numb their feelings of shame. National data suggests that people who experience repeat victimization are more likely to develop mental health challenges, like higher rates of depression and PTSD. A study from the Alliance for Safety and Justice found that 8 out of 10 victims of crime experience at least one symptom of trauma. I see this in the eyes of the women as we talk about faith and redemption. It is common knowledge that the overwhelming majority of incarcerated women are victims of crime. Still, women are the fastest growing prison population in the state. The majority of women are in prison for nonviolent drug and property offenses of probation violations. This is true across the state, though help is not always available to victims of crime, drugs, felonies, and prison is. I can tell you that many of Ohio incarcerated women are the victims of a crime, and that under unaddressed trauma that led them toward drug abuse, risky behavior, and the justice system. These women need our support. They need treatment and ongoing counseling to end the cycle. They do not need felony convictions or to be sent to state prison to become hardened criminals. Criminalizing crime victims who have turned to drugs to numb the pain of their trauma only make their lives harder to live. Felony convictions carry countless barriers that only add to the shame these women already experience. As a crime survivor who almost went down that dark path, had I not found help, I fully support reclassifying drug possession from a felony to a misdemeanor and giving people with prior minor drug possession felonies a fair opportunity and redemption by allowing them to ask courts to reclassify their felonies to misdemeanors. Felony convictions for minor drug possessions make it harder for the women I work with to recover and get their lives on track, whether that felony is 10 years or older, 1 year old, or 1 year old. Another major challenge these women face is probation revocations. Too many people who are honestly working towards recovery to go prison for minor mistakes, these minor mistakes result in prison sentence. In my opinion, this response has not helped. Instead, it diminishes all the hope these people work so hard to rebuild. I ask this committee to consider a non-prison response to minor mistakes made while on probation. There are too many people in Ohio's prisons who should not be there. It has been my mission to help and support these women who in many ways are just like me. I will close my testimony with the urging that Ohio expand trauma recovery centers and ensure that crime victims get treatment, not felonies. I look forward to telling the women I work with about your efforts and seeing their sense of hope restored. Thank you.
Thank you so much, Ms. Mattis, for your moving testimony. Are there any questions for the witness? Seeing none, this does conclude your testimony. Thank you very much for testifying.
Thank you so much.
Is there anyone else that wishes to testify? You may come forward and state who you are and who you represent, and you filled out the forms. Okay. And after this, we won't take any more testimony, but you're welcome to come to the subcommittee in Columbus and testify. We would love to hear from all of you.
Good afternoon, Council. I want to thank you for allowing us to come and speak and be a part of this. You show that there is a possibility of a change in the judicial system in Cleveland, Ohio. This is really horrible what we're dealing with. I am Maurice of the Marbury family, part of Ohio Organized Collaborative. It's an organization that actually tries to assist people coming from prison to reacclimating back into society and to direct them into the right programs and organizations that could be able to assist them. I'm actually excuse me. I'm actually speaking for the management of this Cleveland's faction, which is Robin Turner, who took yesterday. Was not going to be here on an emergency basis, so she asked me to speak, so please forgive me so I didn't write anything down. But as I listened, I wrote down what was going on, and a lot of people from Ohio Organized Collaborative are actually ex-felons who helped felons, who actually rehabilitated themselves and come out to society to sit possibly and try to sit on the seats and where you sit right now to help society come back together as it once was. And so by me not writing anything down, what I do is I speak from the voices and the hearts and the minds of the people who are actually in there with you to tell you right now, I'm going to talk about the things that they talk about, that I heard them speak about. There is actually no rehabilitation within any system or organization within itself. It has to be placed upon the person, the individual. However, we become the adults, the men and the women that we were groomed to be as children. And I say that to say, like the one guy was speaking about how there is no programs outside in the city for us in the inner cities. And I want you to look at this. It's like, why have they shut down 31 schools in the inner cities, but built a maximum security juvenile prison facility in the heart of that same city where they shut down 31 schools. You know, this is, please don't get the judges upset, but this is about finances. And if it's about finances, and the finances in this is based on, honestly, black people, Latins, and now it is branched off into even poor whites, to where the prison systems are being filled right now to the recidivism rate. Look at the recidivism rate right now as opposed to it was in the 80s, when there was rehabilitation and correction. When they changed the name in the late 80s to where there's no longer rehabilitation and correction, it's just prison. There were programs in prison. There were programs on the streets. I remember, well, I don't know if anybody can remember this, but there was GYA basketball, GYA football. There were programs that the children in the communities could go to and get tutored, get lunches and things of that nature. All those things are gone. Why is that? I'm pretty sure, I don't know if you do not, you read the book, The New Jim Crow, where there's a school to prison pipeline, to where now they know from the 6 out of 10, 6 black men will be in prison, and they know them by the ages of 4. Why is this? Why is this a study? Why is this a science that's being performed? The thing is, why is it happening? And we're doing nothing about it. I heard him speak about transparency. And we talked about transparency, and there's a problem in the neighborhoods to where he's like, what's done in the house should stay in the house. I don't believe that. Some things should never be kept secret. And there's a problem, and I hope you don't get upset, but the boys in blue, you do the same thing. Okay, there's good cops. Where are they if they see them wrong being done and they're not doing anything about it? The same situation with those who sit on seats of legislation, those on official capacities, even judges. If you see it being done, Title 18 applies to you. If you see something being done that is wrong, you know something that has been done was wrong. It's your ability to correct it. It's your power and your obligation under the oath that you have taken to correct it. But nothing is being done. So I'll go back to the phrase that Lord Ogden coined. He said, power corrupts, but absolute power corrupts absolutely. To the degrees where now you have immunities to the degrees to where it is hard. I'm listening to some of the situations that was going on. It was like, it's hard for some of the judges and the people who sit on seats of legislature to read this paperwork. I'm tired. I can be on the golf course. I could be in Maui. I can be wherever I want to be. Instead of reading this paper has become too much of a job for me to do as opposed to the life that paper. In a few minutes it takes to read that's connected to that person's life that it's connected to. So in my mind and from my experience, I see that a lot of humanity and mercy has actually left justice. And until we see it like it is and do something about it under Title 18, excuse me, we will continue to go on the course that we are in. We'll continuously digress as a community. Right now, we're talking about drugs right now because guess what? It was always in our communities, in the black communities, the Latin communities, it's there. But now it's an issue because guess what? It's branched off into yours. And now it's going and it's carrying on to the crime and the criminal facilities and factions are going into your neighborhoods. Now it's an issue. What about what's in ours? Something needs to be done about the programming, like the brother was talking about earlier. There needs to be alternatives placed in society. Instead of sending somebody to jail who actually has an issue with drugs, I'm not talking about drug dealers. I'm an ex-drug dealer. I'm not talking about somebody who like I was, that was trying to be slick. See, I'm speaking against him now. Somebody even like I was. I'm talking about somebody who actually has an issue, somebody who actually has a problem. And they're caught with, guess what, amount that can be substantiated as a use. Why send him to prison? That's going to affect the rest of his life of being sick. Send everybody to prison that has cancer, sickle cell anemia, multiple sclerosis. It's a problem. It's an issue. It's a sickness that needs to be dealt with. And when you send them to prison, guess what happens when you come home and not acknowledge the mercy and the justice that is needed to where Myself, I'm going to speak about I knew a guy that watched his mother get high. No father was there. And what he did was he fed his brothers and sisters by getting into the drug game because he felt that there was no alternative, and there was no alternative for him. He saw his mother sleeping with men at night. But this is how he fed and clothed his brothers and sisters. And when he got caught and he went to court, guess what they said? The judge, you had a way. You could have did this. You could have did that. When guess what? A lot of people who sit on the seats of the legislature, you've never experienced what we have. You've never experienced no alternative. So guess what they did with him? They sent him to jail and left his little brothers and sisters out there by themselves. So what he did, he came home as a harder criminal, really a real criminal now. When he wasn't, he was just looking for an alternative to do what was never being done for him. These is our situation. These are our situations in our communities. These are our situations in our societies that you're not faced with. So what we need to do is bring that, excuse me, that mercy, that humanity, that love back to justice, that alternative. Look, what can we do to help this person? And I think some of the judges, or they need to have somebody in the seat sits with them in their courtrooms that have gone through CDCA, a chemical dependency program. So you'll know, or the person will know if this person is playing games or if this person really has an issue. And again, somebody even like myself, because guess what? Again, I'm not talking about people like I was. Right now, I'm a community activist, a mentor. I get called to many schools to speak about, guess what? The things that I use. This is where you're going to be if you keep trying to live like I used to. And we need this. So what about this person that has this problem? Can anything be done about this? And this process, the issue also is with making this retroactive. You have people out here now that will go to jail or get caught. Like there's a bulk amount to get caught with a drug to be diagnosed as being drug trafficking. Why not make a minimum amount to where you would know, or it is a certain package? Even in bulk amount, there's a packaging that could be constituted as drug trafficking. Why not make this minimum amount to where it could be usage, and or you could see this person and understand that this is what this is, and make this drug treated issue instead of sending this person to prison that will be affected for the rest of their life. I committed a crime almost 30 years ago. Do you know there's certain businesses that I cannot own and operate because of my record, and or would get no business from? And you have some people that say, well, you can close your record. Well, guess what? Do you understand that there's still places and certain criteria that allows them to go into your record, even find out something? You're still out of a job. Then you come home with nothing. Again and again, there's no programs. This gentleman was up here talking about the Oriental House. Please excuse me. Talking about the Oriental House. When you go to certain programs, guess what? When you come home, when you go to this halfway house, do you know you still have to pay child support with no job? And he told you you're still on the criteria as being incarcerated. You still have to pay child support. You still have to pay victims of crime. And if you do not have a job, you're in this halfway house. Guess what happens? You go back to jail. So we need to have rehabilitation and correction. If this is about finances, let the system create programs inside the system that can help people reacclimate back into society before they even come home. Not just before you go, but even when you're coming home. So I can step out into society as, guess what? A productive citizen in society with something to look forward to. Because we don't right now.
Thank you for your testimony. I think we have some questions. I know.
Yes.
So you're saying because of the cost that there are already ways that we can set up programs inside the prisons using what's there?
Yes, and you can add to and make more.
But you're saying that you could also, that because of what happened before in the 1980s, that you think that we could use some of the people there to be creative and to have programs inside the prison?
Yes, when I was in prison, when I explain something, when I was in prison, you can go to college. I double majored in psychology and theology in prison, and guess what I came home as? Because it was within me and it was initiated and pushed with other people, I came home a productive citizen in society. Guess what now? There's criteria on everything like the gentleman was speaking about. You have to have a certain amount of time, you can't have too much time, and you can't have this type of case. And then there's no longer degrees. You have to get transferable credits. So you have to come out here and find a college that is willing to accept your credits from that point. So guess what happened when I'm out here doing nothing? I'm gonna go back to what I know how to do. I know what works. I don't want to, but I will.
Thank you. Are there other questions? That's very informative.
Thank you very much, Co-Chair Grindell, and thank you very much for your testimony. It's not often that we get someone with actual experience in an issue that can come forward to testify. I believe in bringing honesty to the situation that we're currently in. And let's be clear, there are people within the hearing of your voice that don't believe we need criminal justice reform and who actually believe that why isn't it a great idea to just lock up people more and to lock them up in a higher rate so that we put people away in prison and or jail so that they can't get to our neighborhood? What bad happens if I do that?
What bad happens if you do that is this type of behavior, like I was talking about, if you don't have any alternatives coming up as a kid, because we hang together. We meet at the malls, we end up socializing with each other. And you have a saying that says, association brings forth assimilation. So guess what happens? We eventually meet and we have fun together, just like rap music and break dancing. Everybody has it now. It's a part of everything, every culture. So now that's back in your society. It's in your community now. If no alternatives are presented, you can go in your neighborhood and listen to rap music. You can see dancing in your neighborhoods. And if you do not create the alternatives where it initiates, it will eventually touch you.
And just to be clear, you're not suggesting that either rap music or hip hop
It's bad.
wrong.
It's not a bad thing. Right.
Using that as an
Right.
analogy to talk about
Right.
poor behavior and
Right.
associated. Just to be clear. Thank you.
Yes, thank you so much.
Anybody else have any questions? Otherwise, like I said, anybody wants to testify next can write up whatever their information is, and we will have you come down to the subcommittee in Columbus. Representative Galante.
Thank you. Thank you so much
Very
for
welcome.
testifying. And again, you've been a great audience. Thank you very much. And we appreciate you. Thank you.
You know, I want to thank the representatives for coming so far away.
Didn't know what it's like for me to drive to Columbus all the
Yeah.
We're adjourned.